second day of the International Conclave on Media and Entertainment Law, organized by the Nuals Alumni Association in collaboration with the National University of Advanced Legal Studies, Kochi. We are thrilled to have you join us for what promises to be an enlightening and engaging series of discussions on the pressing legal issues facing the media and entertainment sectors today. Our esteemed speakers and panelists bring a wealth of knowledge and experience, and we are excited to explore new ideas and perspectives that will help shape the future of this dynamic field. Without further ado, we welcome you to our very first session of the day, a panel discussion titled Behind the Screen, Legal Challenges in the Video Game Industry. We are privileged to have with us two distinguished speakers joining us today, Ms. Emma C. Smizer and Mr. Zachary A. Lewis. First, we are excited to present Ms. Emma C. Smizer, an associate in the Interactive Entertainment Group at Frankfurt Kernet, recognized in Varieties Dealmakers of 2023 Up Next list. Ms. Smizer is emerging as a prominent figure in entertainment law. With her expertise in US data privacy laws, she advises a diverse range of clients within the video game industry, covering the entire life cycle of game production. Her interdisciplinary approach, collaborating closely with experts in traditional entertainment and data privacy, enables her to navigate the complex legal landscape effectively. We are also pleased to welcome Mr. Zachary A. Lewis, associate at Frankfurt Kernet, who specializes in advising clients on technology ventures and intellectual property matters across various industries, including video games. Mr. Lewis's expertise includes licensing transactions, brand deals, and emerging technologies such as virtual reality and artificial intelligence. A cum laude graduate of Temple University's James E. Beasley School of Law, he has made notable contributions to the intersection of law and technology, earning recognition from Marquis Who's Who in America in 2021. Together, Ms. Smizer and Mr. Lewis bring a wealth of knowledge and experience to our discussion. Please join me in welcoming them to the virtual stage. Over to you guys.
Thank you so much.
Thanks.
So we already had our introductions, but Zach and I put together just a little, mostly fun for us, little character sheet from Dungeons & Dragons, for anyone who's familiar. Exactly like Adworth said, my name is Emma Smizer. I'm an associate at Frankfurt Kernet. We work with indie developers, all the way up to triple publishers in the interactive entertainment world. Our work is predominantly transactional in nature, so it's a lot of deal making and compliance guidance. And I'm based in our LA office, as is Zach. And that's a little about me. And I'll let Zach introduce himself.
Thank you, Emma. First of all, I'll just say thank you, Adwaith, and for everyone for attending. Very honored to be here. What I do is I help companies clear everything they want to put in video games that you see or hear. So whether that's font, music, sound effects, voiceover work, vehicles, weapons. I'm constantly advising, developers and publishers on what they are and aren't allowed to put in their games in terms of intellectual property. And I also help advise them on how to use AI and other emerging technologies in a way that's compliant with U.S. regulations. Our firm really does have like a full range of expertise when it comes to setting up entities, hiring all the personnel you're going to need to create a video game. We really are a full-service law firm, but today Emma and I are going to focus on the challenges, particularly in the intellectual property and the data privacy and security space.
So this is kind of our roadmap for the day. We're covering a bit of ground. I think really central to what we want to cover there is more practical discussion about what it is we actually do for our clients. So rather than kind of giving you a sort of rote recitation of facts and any cases that are happening in the U.S., we want to give a kind of more holistic view as to what our practice as games attorneys actually looks like and the challenges in a practical sense that our clients are actually facing and things that we really are advising on. We also have some fun niche humor threaded throughout this. And before we really get into the legal issues, I wanted to give a kind of high, I feel like I'll be saying nothing that anyone doesn't already know here, but I wanted to give a kind of high-level overview of the interactive entertainment and video game ecosystem, particularly from a U.S. perspective. So I have this little fun graphic here that kind of lays it out, but generally, game development starts up here at the upper right-hand side with game developers. Really, that's kind of the beginning piece of game design and game development. Game companies, game studios, and game developers will create games, sometimes in connection with game publishers, either that being something that's being funded in advance or after the game has been developed or partially developed, then the game publisher steps in. Game publishers generally provide a lot of marketing and financial support to game development, and it's without, game publishers are incredibly central and necessary in game design and game creation. Then coming down to distributors, that's really where the games end up being sold, whether that's going to be, in person in a store like Walmart or Target or wherever, or it's going to be an online distributor like Steam or the Epic Games Store, or even on a console like a Switch or a PlayStation or an Xbox device. Streaming services and esports and consumers are kind of an interesting end piece of games, I think. Streaming services, I think it's a really interesting conversation we have within the interactive entertainment world, because I think streaming ends up being a really important marketing piece for game companies and kind of an interesting piece of the community. So much kind of like marketing and press and excitement around games comes from the streaming community of, influencers and esports players and content creators who are streaming these games and, kind of creating a marketplace for people to consume content around games if they're not playing them directly. And then coming to the top for consumers and hardware and software developers, consumers I think is so self-explanatory, but I guess my point with that is that, whether you're buying games and playing them directly, or you're watching somebody else play it through Twitch, or you're just playing something on your phone, I think that gaming is such a presence in our lives, and there's so much of it that occurs, and there's a lot of content consumption and entertainment that comes from the games world. And same with hardware and software developers. I think those are, a less talked about piece of the games world, but really, really central to ultimately how games are made and what drives the sort of technology underlying games. I don't know if you have anything to add on this, Zach.
No, that was a really good overview. The only thing I did want to add from my own introduction is one of the things we also were going to talk about today is gambling, which is another really big component of interactive entertainment. It's separate from the intellectual property and the data privacy side, but I just want to give a preface that all of these topics that you see here in this large chart, each of them could really have an hour-long presentation, especially in the context of the video game industry. So some of them will be covered in more details than others. That being said, please feel free to ask questions. I think the moderator is going to be presenting them to us at the end. So yes, there's a lot that goes into this, and I wouldn't really mention that we're also going to be talking about, time permitting, gambling, in addition to the intellectual property, advertising, and data privacy side.
And I think to Zach's point as well, these are all really tied together, and there's a lot of cross-section that happens between these different areas. So, whether it's going to be consumer protection and how that bleeds into data privacy, or it's intellectual property and how that bleeds into any sort of considerations with artificial intelligence, I think these topics are all very nuanced and interlinked, and I think we're trying to give a more high-level overview and practical overview of what it is that we're actually doing in terms of each of these different distinct areas.
Awesome. So I can get us started just talking about intellectual property in games. Just so you know, in the United States, there are several different kinds of intellectual property. There's copyright, there's trademark, and there's the right of publicity. There's also patents, but you have to have a whole special license to practice patent law in the U.S. We're not patent lawyers. We have them at our firm, but we're not going to cover that today. What is copyright? Some of you may have heard some of this language already, but in the United States, copyright is what protects authors' original works of authorship, fixed and tangible mediums of expression. So what that legal jargon really means is creative works that have been recorded somewhere, whether it is a song, it is source code, it is a book, it's a play, it's a character that's been drawn out, it's sound effects, it's designs of levels for things. This is what copyright actually protects. And not everything that somebody creates is subject to copyright protection. way that it works in the U.S. is that it has to be sufficiently original, and as we're going to talk on later, it has to actually be made from the artistic efforts of a human being, not necessarily artificial intelligence. But the early law did not recognize necessarily that copyright was going to be applicable to video games, and there was actually a case, Atari Games versus Oman in 1992, where the federal courts recognized that this game Breakout, where you basically have to, move a horizontal bar left and right so you can ping, square to knock out other colorful blocks above you, the court said this will be protected by copyright if the requisite level of creativity is met either by individual screens or the relationship of each screen to the others and the accompanying sound effects. So that's sort of like the backbone for why we today can say that video games are audiovisual works protected by copyright in the United States. Let's move on from that. Do you want to talk about copyright infringement across the media?
Yeah, so in addition to games themselves being protectable, and we're going to talk a little bit about other sorts of copyright infringement, I think there's a lot of different cases that have come up over the years where different media embedded in games constitutes or allegedly could constitute copyright infringement. Really interestingly, there's been a number of cases over the years involving tattoos being shown on characters in games. So tattoos themselves under U.S. law are copyrightable pieces of work. So they're original expression fixed in a tangible medium. Yes, they're on someone's body, but they're still protectable works. And so in a couple of these cases, we've seen famous individuals, whether it's athletes or pro wrestlers or famous people with large visible tattoos being depicted inside games. And the discussion of whether or not that recreation of those tattoos in a video game constitutes copyright infringement of the tattoo itself, separately from the game. And there's been a little bit of inconsistent rulings amongst the courts of what is considered protectable. In one of these cases here on the screen, it got down to a place where the court was essentially examining, how many pixels on the screen were actually visible of the tattoo, which I think is an interesting point with games in that it's not like a photograph, it's not like a drawing of something. In a video game, you have to look at, the lens of what this technology is passing through. So when it's being recreated digitally, how many pixels in that are you able to see? How visible is that tattoo? Am I able to see like a very clear outline of what that tattoo is? Can I actually make out what it is? Or is it just kind of a blurry little smudge on somebody's arm that I can see in a game that's, the resolution is, much more narrow, which kind of goes back to the point about the sort of underlying hardware. As games become more complicated or more complex and detailed, we may see more of these issues come up and how things are being recreated in games, and maybe a more faithful recreation than what rose to the level of copyright infringement here. The same is true of photographs and music. In this Jurasek v. Capcom case, which ultimately was dismissed, so we don't have a really good ruling that came out of this. There was a photographer who claimed that their photographs had been taken and used as textural backgrounds in a game. So there were photographs this photographer had taken of broken glass that lined up perfectly with broken glass that you were seeing in a game. And again, we never got a ruling out of this. This was ultimately dismissed and settled between the parties, but it was a kind of interesting moment to see how you could take something that was, a static photograph, and same with the tattoos, bring it into a game and sort of reskin, reuse, repurpose that ultimately underlying static photograph and put it into something like a video game. Music, I think, is actually a little bit more straightforward than photographs and tattoos. There's not really a lot of transition happening. It's just kind of being played within a game. But still, just to note, I think it's an interesting point that we have a kind of cross-media infringement issue that comes up.
And one of the things I want to touch on is like why this matters, and the reason is that copyright infringement can have significant penalties for willful violations. So in the United States, you can be penalized up to $150,000 per work that you've infringed willfully. Courts may also order you to destroy unlawful copies of works that have been, or unlawful, versions or iterations of, or units of things that have been unlawfully copied. And they may also order you to give all of your profits from the infringing work to the creator of the original work. So what does that mean practically? That means practically when you're coming up with any kind of entertainment project, whether it's a video game or something else, you need to have all of these contracts in place with the original creators, with the licensors, to say you have the right to use these tattoos, these photographs, these songs, these sound recordings, not only in your game, but also in advertisements. That's a big thing too, because as we're going to touch on later, there are different legal standards that apply to how much creative freedom you have to use other people's intellectual property in narrative settings like a video game versus in a commercial speech like an advertisement. And so I just want to iterate that the reason why we focus on are you infringing on somebody's copyright is because if you do that, you could end up with six figures, maybe millions of dollars worth of damages in addition to having to turn over all of your profits.
And in a practical sense, how does that translate to work that we're actually doing? It can be something as granular as we're being sent folders and files and looking actually at what these game assets are going to be, or concept designs of what's going to be in a game. So it depends where a game is at in its development process, but the act of doing clearance on different assets in a game, whether it's something that we either already ahead of time know is a third-party piece of art or third-party work somehow, or it's something that they design, maybe they want to create logos for a made-up shoe company that would be in a game. We would be looking at that to make sure what of this is treading a line too closely from an IP infringement perspective, and what is something that we would have to go get clearance on. Is this a piece of work that's in the public domain? Is it not? Who has the rights to this? What do we need to do in order to put this into a game in a way that is safe and legally tenable for our clients?
In terms of protectable versus not protectable elements of games, like we said before, not everything that is created is protected by copyright. Actually, put a pin in that thought, because what does it mean to infringe on somebody's copyright? Let's just make sure that's super clear. The legal standard for whether you commit copyright infringement is whether there's substantial similarity between your new work and the original work that's been allegedly infringed. So back to what Emma's saying, where we are helping, clients understand this storefront for this virtual business looks very similar to a storefront for a real business, or, this vehicle that you want to put in the game is very similar to this other vehicle that exists in real life, right? Oftentimes we have to help clients communicate with their artists, and our clients are either the in-house counsel of these video game companies, or they may be the CEO, the founder of one of the companies. We have to help them communicate with their artists that they need to make substantial changes that a child will be able to recognize in order to not be at risk of copyright infringement. And speaking of behind the screen, the challenges that we're dealing with, a lot of artists want to do, even though their heart's in the right place, they want to do very minuscule artistic changes and then say, look, our vehicle is not the same as this vehicle because the shape of that window is different and this wheel is slightly less thick than that back wheel. And we have to say to them, that's not going to be enough for a jury in America to say you didn't copy that. So again, that's sort of practically speaking, some of the challenges that we have to deal with, making sure that people understand if you are inspired by something that you want to put in your game, it's much easier to start from scratch and pull in elements that you like versus saying, here's the helicopter that is actually in the real world. How do we change it to make it okay for our game? And sometimes clients don't want to start from scratch and they say, this is the helicopter we want to use. We want to copy it. How much do we have to change it so we don't get sued, right? And so that's some of the stuff we have to advise on. But not every single thing in a video game is protectable. So again, there's so much to cover, so I'll just kind of run through this quickly. But things that are not protected by copyright are the text of instructions in video game, rules or general mechanics, board game layouts, point systems. The things that are actually protectable are graphical appearances of the games, major characters like Mario or Lara Croft from Tomb Raider, the plot, the actual story and the narrative of a game, and all kinds of other unique design elements that, again, are actually original and creative and owe their originality to a human being. Another thing that's not protected by copyright is what's called senza faire, which means that there are just things that must be in the scenes for them to make sense, or like they're just so generic that courts say that everyone's allowed to use them. So health bars, you know, in fighting games, the idea of power-ups and health packs, you know, martial arts moves, superpowers, the ability to fly, the ability to shoot laser beams from your eyes, the ability to teleport, just in general, the concept of pirates and ninjas and wizards. These are things that no single entity owns, right? Not to say that if you use Harry Potter, you're not going to be sued by, you know, Harry Potter, but, you know, you can use wizards as a concept and nobody owns wizards. Those are just things that are senza faire. Trademark infringement. I'm going to try not to ramble too much because I could go on, you know, again, all of these can just be their own entire seminars, but trademarks, unlike copyright, you can think of it meant to actually protect consumers. So copyright is sort of meant to protect artists. Trademark is actually meant to protect consumers from fraud, right? So the idea is you are not allowed to use somebody else's source indicator without the permission, right? If you see something like the McDonald's M, you know, that's a promise of a repeated experience. That's what a trademark is. When you see Pikachu, you know something from the Nintendo company is going to be similar to, you know, the products and services that they've previously put out. So trademark, again, is the source indicator of your business in commerce. And the way that you violate somebody's trademark in the United States is by using it in a way that causes a likelihood of consumer confusion. Are you using someone's trademark in a way that's going to make most people think, oh yeah, they probably endorsed this or sponsored this or approved this or had something to do with the fact that this is here? I'll just quickly talk through a few of these cases. So we have the Activision Humvee case, very popular case where Humvee sued the makers of Call of Duty for saying, you know, you're not allowed to put realistic Humvees in our game. We didn't give you permission. The court actually said that this is protected in the United States under the First Amendment because they said that the use of the Humvee was artistically relevant to creating this realistic warfare setting, and it wasn't used in a way or, you know, made so prominent in a way that was explicitly misleading. Yes, it was part of the environment, it was part of the world, it was part of the game, but it wasn't so heavily emphasized in a way that, you know, people would have thought, oh, Humvee must have wanted this to be shown this way. So that's an example of being able to use real trademarks for realistic purposes in the narrative setting of a game. Again, challenges behind the screen. We have to help clients understand that just because you can use it in a game doesn't mean you can necessarily use it in related advertising, because there are different standards there.
I think also really quickly, even if they can use it in a game, we typically tend to advise against it just because you may be incurring scrutiny and ire from companies that, you know, you would still be incurring legal fees to have to respond to any sort of formal letter or formal response from a company that is saying, hey, stop it, we don't want this.
Yeah, we get letters from, you know, vehicle manufacturers and other entities saying, you know, this is what it typically costs to have this in your movie or your video game. You didn't pay it, so now you have to pay up. And even if they're dead wrong, you know, it takes time and money and legal fees to respond to them to assert your position. And oftentimes, you know, we see these cases and there are some favorable decisions right here. Like in this case, same thing. Someone sued Activision, said, you know, you can't put our patches that we actually use in your game. The court said, well, yes, you know, they are allowed to, but it still costs millions of dollars to litigate that decision, right? So it's like Anna is saying, it's much safer to not use anyone's trademarks, but there are defenses that you have in the event that you do. Same situation here. Grand Theft Auto was making fun or poking fun at a strip club in Los Angeles, which is called the Playpen. In their video game, they made a version that was called the Pigpen. And again, the court basically said that consumers aren't going to be confused into thinking that the Playpen sponsored and endorsed this and wanted this pig pen in this game to promote their business. And so for that reason, it was basically held to be, a transformative use of the trademark, not trademark infringement.
I think also this pig pen example is such a good example of what we typically see when it's going to be a trademark issue from game companies. I don't know what it is about game companies that love to have that kind of like Easter egg thing where they're making this like, kind of coy reference to something that's kind of this like nudge, nudge, wink, wink thing that I think they think their consumers will get a kick out of. We get to be the joy killers and be like, ooh, that's kind of a bad idea, but I mean, I feel like this especially is such a good example of what we see so often in the games industry, of people kind of wanting to like either pay homage or kind of poke some fun at something, which we have to be, practical about the legal risks there.
Yeah, they want to make like a pun about like a really popular business and try to change the logo ever so slightly, and we have to evaluate whether or not that's, is it parody? Is it creative enough? Is it transformative? Or is it really like so similar that there's a chance that people are going to be confused? It doesn't have to be everyone, is extremely confident that the allegedly infringed party was supportive of this. Is there a likelihood of consumer confusion? That's the standard for trademark infringement. Just another quick example of a case where a court held that, yes, using this trademarked gun that was relevant at the time frame in a video game was okay, but again, just because you have a winning decision doesn't mean you didn't spend time and hundreds of thousands or maybe even $1 million plus to get that favorable decision. And for every decision that's handed down by the courts, there are dozens, if not hundreds, of cases that have been settled outside with no public knowledge.
And jumping quickly into I think what we've been calling the clone cases or the clone wars. Speaking of infringement, speaking of impermissible wink nudge references, there are a kind of like sort of discrete subset of copyright cases for the video game industry that I think are really fascinating, where it's kind of like a reskinning issue of a game, where it's one game that substantively looks like another. These are just a couple examples of recent clone cases that we've seen in the U.S. courts. I'm not going to get really far in the weeds on all of the details, but these are a couple examples that you see on the screen here between, the visual appearance or the names of characters and what one game company is identifying as being too similar to their own game that they think is copyright infringement. So in this case, it's a game to another game. It's not a trademark or a photo or a piece of music into a game. It's one game is copying another video game. And this gets really into the weeds in the analysis that Zach talked about as to, now we're looking at really substantively, well, what is protectable in a game? So something like this crazy jump in the cannon shot, what of this is considered, instructions or how a game is played versus its actual representation of it? And these cases I think are really interesting because, taking a step back of how we deal with this with clients, whether our client is someone who thinks that their game has been infringed, or we're defending a game company who's being told that their game is infringing, we really have to get into the weeds, and I will be looking at two games side by side, taking photos, comparing them back and forth, evaluating each little element, like these icons in the game are really similar, or this character is really similar, or even the user flow is really similar, the way that this menu is set up is really similar. And then having to break down, okay, well, what of all these similarities are protectable elements, and what of these are things that are not protectable? And even then, it kind of goes to the same issue about, you can be right and you can be vindicated in a court, but what is ultimately going to be worth fighting is kind of a different issue. And I think that it's still an important, thing to consider, that there is these, clone games that come out from one another, and it is kind of a common occurrence in the games industry, but it's been an interesting area to see lately.
Another thing that is intellectual property adjacent, it is intellectual property, but some people would just say it's copyright, trademark, patent. But in the entertainment industry, right of publicity is very important. And in the United States, people have rights to exploit their own likeness commercially and to exclude other people from doing that. And so if somebody is to sue you and to say that you use my name, my image, my likeness, my voice, my persona in a way that violates my right of publicity, what a court asks is whether or not the use was merely like exploiting this person just for monetary gain, or if, even though, you know, the character looks like them or sounds like them, if they've been transformed, if there have been so many creative elements added that it's transformed in a way that actually warrants protection under the First Amendment as an expressive creative work. And so we're going to go through a few just examples of cases and let you know how they turned out. It's interesting. I would have really liked to see if we could have like people's responses in chat to see whether they think the use of this person is transformative or not. But in this case, Kirby v. Sega of America, there was a lead singer of a group called D-Light who claimed that Sega violated her right of publicity by creating this Eulala character in Space Channel 5. And the court said that even though, I guess we can't pop quiz people and see whether or not they would say it's transformative. But in your head, think about whether or not you look at this character and you immediately think that they're trying to exploit the person's likeness on the left. The court said that even though, you know, they use this person's likeness, they did add enough creative elements to make it a new character, which entitled them to First Amendment protection. The direct quote is that this character had a physique, a unique physique, a primary hairstyle, and costumes and dance moves that differed from the real person's, and the setting for the game, which was in space, was unlike any setting that the actual singer on Earth participated in. And that's going to be relevant later too, so hold that thought. So this is a scenario where Activision had a license from Gwen Stefani, from No Doubt, to recreate her for their video game. They did it in a way that exceeded the scope of the license, allegedly. Like, they put her in, you know, positions and had her, you know, moving around in ways that she didn't approve of. And so she sued and said, you violated my right of publicity by going out of the scope of this agreement. And so just take a few seconds in your head to think about whether, you know, this image on the right is a transformation of the person on the left, or if it's really just using their likeness for commercial benefit. Well, the court actually said that this was not a transformative use and that it was a violation of their right of publicity because even though there are some creative elements, what the character in the game is doing is no different than what the person in real life is doing. They are depicting the exact activities that Gwen Stefani actually performs in real life as a celebrity, which means that her right of publicity was violated here because it was used without her permission.
Because she wasn't in space.
Yes, if she actually performed in space more often than, or if they had put her in space, you know, that would have been a little bit safer. Hart v. Electronic Arts. This is a class action filed in New Jersey, where a bunch of collegiate athletes argued that Electronic Arts violated their right of publicity by putting their clothing, their accessories, their biographical data, and their likeness in these sports video games. And take a few seconds to think about it. But the court held, just like they did with putting the singer in the singing game, they held that when you put these athletes in this football game, it was not a transformative use of their right of publicity, especially because the whole point of the video game is for them to do the activities that they, you know, have become known for doing in the real world. And
should have put them in space.
The court said, you know, the type and the extent of the interactivity is sufficient to transform. They have to look at whether the type and extent of the interactivity in a new use is sufficient to transform the likeness into a new expression. When you're transforming somebody who throws a ball into a digital person who looks like them who throws a ball, that's not very transformative. On the contrary, there's another football player who sued creators of Gears of War, Epic, because after alleging that Coltrane from the Gears of War series violated his right of publicity, and the court said that the defendant's First Amendment rights actually outweighed the plaintiff's right of publicity. So even though there are some similarities between the physical appearance and the voice, and even like the career history of the real football player and the character in the video game, the court said that because they had different names, clothing, and they appeared in different contexts, playing football on Earth versus fighting aliens, from space, or fighting reptilian humanoids in outer space is the exact wording. That was actually so different that any similarity was transformed enough to not violate their right of publicity. So I jokingly tell clients that if you want to, avoid ROP issues, just put people in outer space, because they're not doing that in real life. Even if you're not trying to copy someone's name and likeness, you might just get a claim that happened. Activision got a claim over Grand Theft Auto that they used Lindsay Lohan's name and likeness, without a permission. The court said that consumers aren't going to really think this is Lindsay Lohan. This is just a very generic, distinct, satirical representation of a modern beach-going young woman. And because nothing was super identifiable to Lindsay Lohan, there was no liability there. But again, it's not great press, and it also takes a lot of time and money to resolve these sort of claims.
And I think the thing I'll just add really quickly, this was never a lawsuit, but for anyone who's familiar with the franchise The Last of Us, there was a claim, not a formal claim, but there was some suggestion that the character of Ellie looked like Elliot Page, then Ellen Page, in their likeness. And I think it goes back to the point we brought up around tattoos and there being a kind of issue with how something is then generated into a video game. Sometimes there can be a likeness of someone when, even if they're based on an existing person or an existing likeness of someone else, the way that it translates into the actual medium of a video game can end up, I think, sometimes looking like it's something that they don't actually mean. I think it's just kind of a fun, interesting example. And I think this now is my turn. So we're taking a step away from kind of like infringement and protectable elements, and now we're talking about the kind of inverse of this. So when are we doing things where we're creating new pieces of art or new pieces of work based on video games? And lately, although it's not exactly a new trend, I think we've seen an increased uptick in video game adaptations. So existing underlying video game IP that has been turned into film or TV. We've seen a couple of these different agreements come across our desk. This is something that I've been kind of seeing a lot more lately. These deals are really interesting, I think, because they serve two really different, unique purposes for both sides of the table. So on the one hand, you have the games industry, which I think in order to bring and drive attention back to games, a lot of game companies are now really interested in having these film and TV adaptations. So something like Arcane is a really great example where, I've never played League of Legends, but I certainly did watch Arcane, the show on Netflix, and there's been a marked increase of people playing League of Legends after that show has come out. I think because you're opening up the games industry to a new segment of people and allowing a kind of inroad into the story of what's within the games world. On the other side, I think for film and TV, what's really beneficial for film and TV is that you're tapping into an existing audience. So you're not taking new intellectual property and trying to create an audience for it or find an audience for it. You already have an audience. So for something like The Last of Us or for The Witcher, those have strong existing fan bases built off of the creation of the game and the world of the game that then can be used and translated into film and TV. These deals ultimately are really, really complicated, and like Zach said, we could spend an entire hour to 90-minute presentation on how rights deals are structured between games into film and TV, and even the inverse of it. I think what's really interesting to note here is that in typical option purchase agreements, there's kind of these like 4 categories of rights that are being held. The granted rights, which is usually what it is that you're being allowed to do. So for game companies, If you're allowing someone to make a motion picture adaptation or a piece of film or an animated TV series, that's what you're granting. Reserved rights is a really interesting concept that really only exists in the film and TV world, that I think has been really new and different for games to see. It's the idea that actually, I'm sorry, that's frozen rights. Let me stick to reserved rights really quickly. Reserved rights is not a new concept. Game companies are, holding back certain rights that they want to make, and whether that's going to be they want to do a live action TV series, they want to do an animated series, they want to do a podcast, a live play. It's typically going to be rights that you're holding back, that the game company retains, that they're not giving away or licensing away to a studio, that they maintain the right to still exploit. These rights tend to be something that's going to not compete with the thing it is you're licensing away. So if I'm licensing away the rights to make, an animated feature film, then typically I would not be able to reserve an animated TV series. You would see that being tucked into what's the third category, which is the kind of new category for games, which is what's called frozen rights. These rights are frozen, meaning that nobody gets to exploit them. So if I'm a game company and I'm licensing away the right to make an animated TV show, what might be frozen is an animated motion picture, an animated feature-length motion picture. Typically, the frozen rights are going to be things that you're saying, me, the game company, even though I had these rights before the option purchase agreement, now in light of this license, I am not going to do this because it could be harmful to the thing that, the motion picture or the TV series that is going to be made. It could be competitive, or it's just that they want to be able to hold onto those rights to, lock them down in case the studio wants to exploit them at a later time. And again, these deals end up being really complicated. Some of the big issues that come up in it is the creation of new intellectual property between the game and the film or the TV series. Once the TV series is made or the motion picture is made, if it's creating new characters or it's adding new material elements to the game universe, what are the games allowed to then use in their games if the games are still being made, because it's an active intellectual property, an active franchise? What then do the studios get to have on the other side of it to bring into production of film or TV? That can get really complicated. Another really big sticking point tends to be the issue of trademarks between the game studios and the film studios. If I'm an existing game company with an existing game franchise, I want to hang on to my trademarks because that's my place in the marketplace. That's my indicator. So my ability to trademark my characters or certain aspects of my games is really central to me. If I license away the right to make a TV show or a movie, and a studio makes something new, they make a new character, can they also get trademarks in those characters or those new elements, those new, the new pieces that they're adding to this? It becomes really all subject to negotiation, and I think it ends up being very robust and complicated deals because game companies are really active, sometimes very large participants in the marketplace. And what ends up being, kind of taking a look at the practical piece of it, what ends up being a big indicator of how much leverage each party has, ends up being the financial contribution to one side or the other. So if the film studio is investing money into the games, or if the game studio is investing money into the creation of the film or the TV show, that tends to kind of tip the needle on how favorable the terms would be to one or the other. And now we're moving into artificial intelligence. I think I won't spend a ton of time on this, and Zach, please feel free to jump in. I think artificial intelligence is like this massive buzzword that we've spent a lot of time talking about in the United States. So I think I'm sure you all have as well. So I have a lot of artificial intelligence fatigue. In my mind, I think of artificial intelligence as being this really fleshed out, almost person-like thing. So to me, I feel like ChatGPT and artificial intelligence doesn't quite fit my imagining of what artificial intelligence looks like in the future, where it's something kind of more real. But in the US, there has been some case law and some decisions coming out of the Copyright Office as to what is considered protectable and transformative from artificial intelligence. So this case is a really good example. This is the Théâtre d'Opéra Spatial. So you can see the image was originally created in Midjourney, and then an artist took the image and kind of respun it, reworked it, and then made the one on the right-hand side. And you can see how they are really similar. I'm not sure how well you can see the screen on your side, but the image on the right definitely has some differences in the image on the left. I'm sorry, I'm just looking at your thing. But there's some working between them. Ultimately, what the Copyright Office has said is that there is a requirement to give some kind of like de minimis standard of disclaimer of what amount of artificial intelligence is being used in something. And the only point that I have with this slide is just to say very quickly, some time ago, back in 2014, there was a game release called Shadow of Mordor, in which Warner Brothers used what later became a patented system called the Nemesis system. And if you look at their patent, it references artificial intelligence in it, which I just think is interesting because we're living in like the kind of like buzzword time of artificial intelligence, but it's certainly been something that's been around for games for a long time. And I think I can like really speed run through data privacy.
Yeah, we're gonna do the Q&A in like just a couple minutes. I'm just putting in the chat. I don't know if you saw that.
Yeah, I did.
Okay.
Yeah, we can start the Q&A whenever. I'll be super quick on data privacy. It's exactly what it sounds like. I think it's kind of top of mind for everyone and has been for a long time. Children's protections in games is really big for us. We spend a lot of time thinking about, children playing video games, what data is collected from them, and what you do with it and what you're allowed to do with it. There are laws in the U.S. that govern this. Children under the age of 13 and then children 13 to 18 on a state level. We are kind of pre-homogenous laws in the U.S. of how to handle minors' data, except for those under the age of 13. So still a very developing area, and we've seen a lot of movement from regulators in this space.
Yeah, like we said, there's so much that we could cover. We're happy to come back and do more presentations on loot boxes, gambling, data privacy. We can dive so much more into AI, other kinds of IP. There really is so much to do. And we're happy to answer follow-up questions. If you don't have your question answered here, just send us an email and we're happy to chat or give another presentation.
Yeah, I think we really do have a lot of slides here, don't we? That kind of covers. I mean, this is essentially a very fast, high-level overview of what it is that Zach and I consider every day when we are counseling our clients.
Yeah, so that was great. In fact, we would also like to hear much more from you, but the fact of the matter is that we do have a time schedule to stick to. So I will just take the liberty of concluding very quickly. So that brings us to the end of the session on the legal and ethical challenges in the video game industry. And the session was very kindly sponsored by RM Legal. So with that said, let's move on to the Q&A session. So Ashwin from the other end will be screen sharing the questions, and I will be reading out the questions to all of you. So as you can see from the screen, the first question that we have is interactive entertainment is a motherlode of copyright, as it is bringing together different types of works like video, audio, art, literature, etc. to form an all-encompassing mega work?
I am curious to hear Emma's thoughts on that, but I personally think that between interactive entertainment and traditional entertainment, those are the motherlodes of copyright. I like the wording of that question, because when you're creating, a screenplay, or you're creating just a book, or you're creating just a song, your goal is to come up with one creative work. But like you're saying, like you're recognizing here, in order to make a video game, it is actually the culmination of several dozens, if not hundreds, of creative individual works, whether that's individual character designs, sound effects, scripts, dialogue, things like that, artwork, So I would say that it's a very good way to think about it. And my quick answer is yes, it is the motherlode of copyright. But I'm sure that there's, entertainment lawyers who would laugh at that, and they would say, it's actually much more involved to make a movie than a video game. So
I think from a legal perspective, the motherlode of copyright ends up being music, only because of how the rights are structured between a composition and a master recording. And that's like a whole different can of worms. For video games, when you register a video game for copyright protection in the United States, you're registering it as one homogeneous audiovisual work. So you're not, when you have a video game, you're not registering the script, the music, the game itself typically. Like you really are seeing it as one whole piece together. You may see some music, going back to music being the motherlode of copyright, you may see some music be separately copyrighted, but generally for a TV series, a film, a video game, those are one, when you file that registration in the United States for copyright protection, that's one whole piece of work.
Okay, great. So the next question, moving on to the next question. The question that we have is, if I take a screenshot of a game, do I own the copyright to the photograph as I am the photographer / author of the work?
Technically, you would be the owner of the photograph, but again, a couple questions would have to come up. One, is there enough creativity in the photograph for it to be copyrightable? And it would, if it's a screenshot of just a black screen, probably not. If it's a screenshot of like a very artistic fight with a dragon, maybe. However, I would say that you're probably going to have a very thin layer of copyright protection to the extent you have any copyright protection at all, which means that, if I'm the video game developer and you're the person who took a screenshot of my game and both of us want to go sue somebody who's using that screenshot on a t-shirt to sell the t-shirt, a court is much more likely to say that I've been injured than you've been injured.
Also, it goes to the question of substantial similarity in terms of infringement. So if the thing that I'm making substantially is similar to something else that already exists that is copyrighted, your protection really isn't there.
True. So if it's a screenshot of something very generic, right, that you see in almost every video game, then it's not really going to give you enough protection to be, actionable at law. I'm reading this question, but do you want to read it out loud for the audience, Edwin?
Yeah, if I may, I'll read it out loud to the audience as well. So the next question is, how does the transfer of ownership of a game happen? Is it a combination of assignment agreements for different aspects of the game, or a technology transfer agreement type of one-shot deal?
I think the answer is both, depending on the life, like where you are at in the life cycle of the game. When you're actually developing the game, it is, making sure that you have chain of title proven, you have, agreements, assignment agreements, or licenses in place for all of the contributors to the video game. And then, like Emma mentioned, once that game is registered for copyright protection as its own, entity, then you could have just one agreement that says, I am hereby licensing or selling or transferring to you all right, title, and interest in into the video game and all constituent elements. And so then it can just be sort of done in one, long, but one agreement.
Typically, rights are consolidated, ultimately, finally, under the umbrella of one entity, one company. And that one entity and one company can sort of dispose of those rights as they want. So what may happen with a game developer, if they're purchased by a publisher, or if they sell the game to a publisher or a distributor, those copyrights then are transferred kind of ultimately in a simple manner. But again, like Zach is saying, you want to get the kind of chain of title and make sure you have everything underlying it to make that one piece.
All right. So the next question that has been raised is, any advice for a law student aspiring to be an interactive entertainment lawyer?
Do you want to go first, Emma? What do you think?
I will take it first. I think what's really important in interactive entertainment is to, love it in some ways. I think playing games and really enjoying them is such a big piece of it. I think, Zach and I are both gamers. I think we sort of are really interested in the space as a whole. And then I think also putting yourself out there, speaking with people, making those connections and kind of meeting other people and seeing what they do. I think putting yourself out there and building a network of people that you want to work with or want to work for is really important.
I have to agree. Those are the two main things I was going to say. One, play the games, or just be passionate about whatever you're going to be talking about with people. And number two, make these meaningful connections, because it only takes one human being to change your life forever. When I started my legal career 6 years ago, I was working on murder cases. And for me to be in Philadelphia, other side of the country, the United States, I was working on very, saddening, heavy stuff, because I just had a few really good conversations with a few of the right attorneys. I got to relocate to the other side of the country and start working on some of the most, exciting and fun, matters. I got to work on the motherload of copyright now instead of some of the other stuff. So I would definitely say that, there's nothing more valuable than a genuine person who has your interest at heart and wants to see you flourish in your career. I owe a lot of my success to just people like that. And so I always try to pay that forward as well if people want to reach out to me.
Right. So the next question that we have is, even though COD has been out since 2003, in mobile adaptations, PUBG is considered to be the leading FPS game, especially in South and East Asia. Do you think this impacts COD/the publishers in any way?
I think that one of the things that I always take away from, we attend a lot of different game conferences, is that the game industry is massive, and there are so many different, I guess, competitors, but I think different discrete markets, and whether that's territory or games themselves. I think there are some game companies that lend themselves to one territory over another based on their marketing and their audience. But also I think that each game is kind of its own distinct thing that seems to have its own distinct audience that surrounds it. So I think my answer is, no, not necessarily.
All right. So the next question, when it comes to tattoos, photos, etc. in video games, shouldn't the measure of copyright liability be based on the level of profit that is being made from the inclusion of these works?
That is one component of the calculation of damages in copyright. So how much of the market value have you really taken away from the original work? If you release a song and I release a song that's very similar and no one has to listen to yours because they can listen to mine, that's very different than, if I make a video game and it has a photograph in it, no one's going to go buy your photograph, right? Like those are just two different arguments. So the level of profit that's being made from the inclusion of the works is a factor, but what's also really important is the willfulness of the infringement. If you can prove that there was a willful copying, that's when you can be charged with up to $150,000 per work. So that's why it's really, important to not do that. Because that is probably, in the most cases, I would say that's probably more than a lost profit. Maybe when you're talking about a massive video game, it won't be, but when you're talking about things like tattoos, photographs, songs that aren't billion streams songs, you really want to watch out for those punitive damages.
All right. So the next question that we have is, Rockstar has, in the past, left pieces of unlicensed music in the GTA files that weren't known to the owners till fans discovered it. Shouldn't copyright owners be more responsible for their works?
That's a client of ours, and that's blasphemous. No, but in all seriousness, copyright owners should be responsible for their works. And you actually, on that note, you have a duty to register your work before you're able to sue anybody for it. So if you haven't gone to the Copyright Office and said, here is my work, I want to register for copyright protection, you don't have any standing in the United States to sue anybody for infringement. So you definitely want to be responsible for your works. You want to get it registered with the Copyright Office. You want to be, able to prove how much you would actually charge for a license to your work. So that way, if somebody does not pay you, you can say to a court, here's what I should have been paid, not just, shaking your fist. To what extent is it? Okay,
right. The next question. Yeah. No, please, Mr. Lewis, please go ahead.
Oh, I was going to say, to what extent does the Digimon franchise infringe on the IP of the Pokemon franchise? If this is a veiled attempt to get us to discuss Power World and Pokemon, I also can't do that because Nintendo and Pokemon is a client of ours. But I will say that, I think that when it comes from a copyright perspective, I do think that there aren't many Mons that are substantially, I don't think there are many Pokemon that are so substantially similar to Digimon that the works as a whole could say that, Pokemon is infringing on Digimon or vice versa. Obviously, they're sort of inspired by a lot of the same concepts. And in general, when you're creating monsters that are based off animals that exist in the world, there's only so much you can do with them. So clearly they don't infringe enough for there to have been extended litigation over it. So, there's peace for now.
So for something like this, where you're creating your own story. Still, even then, like I think this goes to the issue of like what is copyrightable in a game and what is not. Even something like this would still, I think, I don't know, Zach, if you feel differently. I think generally lies with the game makers, that they typically would be the ones who would own the copyright to this, because they're the one who is thinking through, even though you are making these different decisions, they are the ones that have storyboarded out the decisions that you're making. You know, your decisions are not, in most games, infinite. They are finite in that there's only so many decisions that can be made in a game, and those possibilities have been contemplated by the game makers. I think I'm understanding this question about piracy. I think I get it. I'm not sure about what, to what extent AI can prevent piracy for games. I think it's sort of a separate issue about security and kind of like, I don't know, like different unlawful ways.
If anything, it might be the opposite, where AI is going to be able to like take a game and sort of like reverse engineer it very quickly. Hopefully, you're going to have to come up. There will be vendors who come up with, other kinds of combative AI that can prevent that sort of misuse in the first place. I think that's what it will come down to. Just a battle of who has the better AI, the hackers or the developers. How advertising on online games are regulated. So whether your game is online or whether it's on a console, it's generally regulated the same under like U.S. laws. We tell people the two main rules are tell the truth and don't rip people off. And if you follow those two rules in the United States, you're probably not violating advertising laws. Obviously, that's a very simplified way to put it, but again, if you're being honest and you're not, stealing money from people, you're probably in the green, as we say.
And long story short, I think like all advertising in the U.S. is ultimately regulated. So whether, like Zach said, whether it's appearing in a game or not, all advertisements are in some way or another regulated by different U.S. state laws and federal law.
Right. So I believe we were able to answer most of the questions. We might have missed out a few again because of the set time constraints. But that was a wonderful session. Thank you to both the speakers, Ms. Ima, Ms. Lewis. Thank you to both of you. It was very wonderful, and we hope to have such sessions with the both of you ahead in the future too. Thank you so much for being with us. Thank you.
Absolutely. Thank you, everyone. Enjoy the rest of the day.
Participants, please remain seated. Before we begin the next session, we will be taking the attendance for the session. So kindly remain seated so that the volunteers can go around with your attendance.
I'll be calling out the IC code. Please raise your hands if you're present. IC 139. IC 84, IC 3, IC 1, IC 136. Since most of you are not here, we'll take it combined after this session. And please come forward, participants. Please fill in the chairs that are ahead of you. I urge you to come forward, please. Those who are taking seats in the chairs behind, please come forward and occupy the seats in the front.
check.
Participants, please settle down. We will be beginning the session shortly.
Participants, please settle down. We'll be beginning our next session. Ladies and gentlemen, we now begin the next session, Copyright and AI in India, a roadmap for the future, which is kindly brought to us by our wonderful sponsor, Nihas Bashir, a partner at Vadya Gandhi. It is now a pleasure to introduce Professor Dr. Arul George Skaria, our distinguished speaker for this special lecture. Professor Skaria is an Associate Professor of Law Professor Skaria is an Associate Professor of Law at the prestigious National Law School of India University in Bengaluru. With over 17 years of experience spanning academia, research, and legal practice, he brings a wealth of knowledge to the complex intersection of law, science, and technology. Professor Skaria's expertise is further enhanced by his role as an affiliate faculty member for the Copyright X and Patent X courses at the Harvard Law School. He has also authored 2 sole-authored books published by renowned academic presses, Piracy in the Indian Film Industry, Copyright and Cultural Consonance by Cambridge University Press, and Ambush Marketing, Game Within a Game by Oxford University Press.
I think that's more than sufficient to introduce me. So very good morning, everyone. So we are running late by 15 minutes, so I just didn't want to take more time on the introduction because I think we should make best use of our time for having maximum interaction today. It's always a pleasure to be at Nuals, so this is not the first time I'm at Nuals, and I'm always impressed by the amount of efforts put in by the Nuals students, as well as also the kind of questions they always pose. So I'm very much excited to be here. And special thanks to all the organizers, particularly Anupama, for taking care of all the things relating to my participation here. So as you might notice from the title, I'm going to talk in the next couple of minutes about the interface between copyright law and artificial intelligence. And as the second part, or the subtitle indicates, through this interaction, I would also like to share with you some ideas which I want to discuss with you regarding how India as a country might want to address this interface. So I divide the presentation into almost like 4 parts. We'll have a very brief introduction on why we should be discussing this. Then I would focus on the 2 primary copyright related questions that are emerging in the context of interface between copyright and AI. Then I would like to also highlight what approaches are currently taken by different jurisdictions with respect to 2 of those issues. And then, yes, as I mentioned earlier, I would like to discuss with you maybe 5 ideas relating to how we might want to navigate through this particular terrain. So let's move quickly to the first part. So I guess this is something which is quite obvious for everyone who is sitting here, because There isn't a day now wherein we are not seeing people talking about how much economic value AI might be bringing in. But one of the things which you might also want to very carefully check there is, are the valuations same? The valuations are absolutely different. And it's also not too surprising considering the fact that no one really knows what exactly is the potential or what exactly are the kind of changes that might be brought in by AI. But at least there is a general consensus among everyone that yes, AI is going to be playing a major part in the GDP of most of the jurisdictions. So I think that's the place where we all have agreement. It is also interesting to see that some would say, yes, AI is going to prioritize our humanity, and this includes our wonderful friend, Sam Altman, as most of you know, the founder of OpenAI. But there are also people who say that maybe this is the beginning of a disaster movie, so we do not know where we will end up. And maybe we are already seeing some signs of it in terms of the less number of recruitments that are happening even in some of our premier institutions. So as most of you might have read from the news reports, even IITs are now struggling to find placements for everyone. Of course, I don't attribute a causation here, but it's quite possible that there is a correlation between the two, because if some of the entry-level jobs can be done with the help of AI, then yeah, why should I recruit more people, right? And the same can happen with respect to the legal profession also. So there are people who also believe that maybe yes, not everything is rosy with AI. There might also be disasters coming our way. It is also interesting to notice that yes, we are not really prepared, but maybe yes, we have to ask many of these AI tools for solutions, and let's hope for some solution coming up soon. Interestingly, people who benefited completely from an unregulated environment is now beginning to say that we need to be regulated. Again, Sam Altman would be a good guy to point out in this regard, because if there is one firm that regulated maximum from the unregulated character of this industry, that's OpenAI and Sam Altman. But now you will notice him suggesting that we might need International Atomic Energy Agency like regulation. That's the highest level regulation, right? Again, I do not know whether that's the most optimal approach, but yes, at least there are discussions happening in this particular regard. So one of the reasons why we have to discuss about the interface between AI and copyright is the fact that there is now general consensus that there needs more regulations in this particular area. So again, that's one area wherein I think we are slowly seeing consensus. The other important thing to be mindful is, if we are talking about regulation, we have to also talk about where India stands in terms of innovation and creativity with respect to AI, and how we frame regulations that enhances our position as well as contributions in this particular area. So if you look at one of the very recent studies that have come up in this regard, it shows a very disappointing figure, that is only around 1.4% of papers shared in top 10 AI conferences are coming from India. So again, we are using this as a proxy to see how much innovation is happening with respect to AI. We are wonderful users of AI, but here the question is, are we also contributing towards the development of AI? With respect to that dimension, it is kind of evident from different studies, including this one, that we still have a very, very long way to go as compared to many people, including our neighbor China. It is also important to understand that AI is going to make huge impacts in terms of artistic creativity. So today, before the presentation, I was asking Dali to give me a picture that presents a future of creativity in the AI context. Of course, the first one that gave was a very rosy picture. And here you can see that. Of course, that's not what I really meant. So I said, what are the potential negative ones? And then, yes, it showed me this one. And again, I wasn't satisfied there. So what I asked was, can you actually contextualize it in the context of a country like India? And this is what it generated. Of course, I mean, these three pictures themselves show many problems, which I hope some of the other speakers will address, including different kinds of biases. For example, when I'm asking to produce a picture of an artist, as you might have noticed, it is producing a male artist. So there is clearly a gender bias. And when I'm asking it to produce with respect to India, again you will see someone with a very white complexion. So these are some of the inherent biases, which of course I wouldn't be able to discuss today because our topic is limited to copyright and AI, but which you should be mindful about. But the broader point which I wanted to bring through these three pictures is the fact that yes, AI is also challenging many of the artists. Of course, as you might have also seen from the many, I would say, interviews with artists, many of them feel threatened by the emergence of these tools. But having said that, there will also be a strong set of people, including me, who feel enabled by AI, because if you had asked me to draw this, I would have never been able to draw something like that. So there is a bit of democratization or substantial democratization with respect to creation of artistic works happening with the help of AI. But what is important to understand is that AI is completely going to revolutionize the field of art, music, and every other form of creativity. So from that perspective also, it is extremely important that we discuss about the interface between copyright and AI. So with that brief background, let's look at the two questions. So when it comes to the interface between copyright and AI, there are many issues. Again, we have only like now 45 minutes. So what we are going to do is we pick up two of the most fundamental questions here. One is the question of ownership. So who owns works that are created by AI or with the assistance of AI? Again, I am making a differentiation here because we are slowly moving to a stage wherein AI will also be autonomously generate works. So that's one subset there. The other one is the current scenario wherein, yes, you and I are using tools like DALL-E, Midjourney, etc. to create works like this. So even in this context, yes, who is owning the intellectual property in the output that is generated is a very fundamental question that we will have to ask. So that's the first set of questions. The second is relating to copyright infringement. Again, as most of you are aware of, with respect to any of the models, it is an established fact, undisputed, that most of them have used many different kinds of copyrighted materials for training. If they hadn't had access to copyrighted materials, they would have never ever been able to make these models. Now, the question that arises is, when you are using a copyrighted material, like say for example a piece of music or a piece of art or some of the writings as part of the training, are we also infringing the rights of the concerned persons? So again, a very complex issue, and it's a good idea to now see how different jurisdictions are currently approaching these issues. So here I would like to start with the country that I think is again at the most advanced stage in terms of litigations. I'm not saying most advanced in terms of technology because that's again something that would be debatable, but at least in terms of litigations, the United States is leading the show. And on the screen, you will see one piece of art which got the first place in the Colorado State Fair. But one of the interesting things that was revealed subsequent to the winning of this particular prize was that the concerned artist, Jason, had used Midjourney for creating this particular piece of art. Again, it's not the way you and I generally prompt on these tools. He had used more than 500 prompts to reach this particular painting. Now, the question which the US Copyright Office had to deal with when it came for a registration was, can it be granted copyright protection? The answer given by the US Copyright Office was no, because the US copyright is human-centered, and you need a human to be the author of that particular work. So in the specific context of the painting which I mentioned, even though the author had put in more than 500 prompts to reach where he eventually reached, one of the very important things which the Copyright Office pointed out was the fact that A is still a black box. So you might think that you are at the steering wheel, but the final decision on what output should be produced is still made by the concerned AI tool. So again, I mean, this is something which many of you might have experienced from ChatGPT. So again, ChatGPT will give us the feeling that yes, we are actually the ones who are really driving the show. But at the end, ChatGPT has enormous amount of discretion within it to decide what output should be reached. Of course, I mean, with more and more prompts, you will be traveling in a particular direction. But what the US Copyright Office has pointed out in that particular case was that it is still a black box, and as it stands now, we will not be able to grant copyright protection for that. And the US Copyright Office also had released some guidelines in this particular regard last year, and there, based on the existing case laws as well as the review of the statutory provisions, they re-emphasize the fact that copyright can protect only material that is a product of human creativity. Of course, the Copyright Office, if you look at that particular guidelines, has also left open the possibility for registrations in cases where you can show that you are the one who is actually producing it. But then again, the technology has to evolve a little bit more to point out that yes, you were the one at the driving seat. This is yet another interesting one from the US Copyright Office. So here it was a comic strip that was subject of litigation. And initially copyright protection was granted for this particular work. But then the Copyright Office realized that the images that are part of this particular work were generated using Gen AI tools. Then you will notice that they sent a very nice letter. And I really love the way the US Copyright Office communicates. With absolute clarity, they said that we conclude that Ms. Casanova is the author of the work's text, as well as selection, coordination, and arrangement of the work's written and visual elements. That authorship is protected by copyright. However, as discussed below, the images in the work that were generated by Midjourney technology are not the product of human authorship. Because the current registration for the work does not disclaim its Midjourney generated content, we intend to cancel the original certificate issued to Ms. Casanova. So no ambiguity, they are very, very clear what they are doing. And that's the advantage which I am currently seeing with the current approach of the US Copyright Office. Now let's look at what China is doing. So again, with respect to China, the most important case law so far is Shenzhen Tencent versus Shanghai Yingsun. Both of them are news agencies. So Tencent Technology had evolved something called Dream Writer, which was an intelligent writing assistant system to meet the needs of large-scale and personalized content business. And they had granted license to Shenzhen Tencent, which is one of the major newspapers there. And they published an article with the help of this. And towards the end of that article, they had also categorically mentioned that this article was automatically written by Tencent's robot, Dream Writer. So that disclaimer or disclosure was absolutely done by the people who generated it. Then one of the rival newspapers, that is Shanghai Yingsun, reprinted that particular article under the presumption that there is no copyright in that particular work. Of course, Shenzhen Tencent was not very happy to see that happening. So what they did was they initiated a copyright infringement suit against the rival company. Interestingly, in this particular case, you will notice from the slide that the Chinese court took a slightly pragmatic approach. They didn't look into the question of whether AI can be the author. What they did was they said, in terms of this particular article, arrangement and selection of the creative terms in terms of data input, trigger condition setting, template, and corpus style choices are intellectual activities that have a direct connection with the specific expression of the article involved. So instead of addressing the complex issue of whether AI can be an author, they pointed out that with respect to this one, because of the activities done by the content curators, let's put it this way, they meet the requirements of originality under the Chinese copyright law. So that's where China stands even now. Then comes our jurisdiction, India. So here again you are seeing one artwork which was generated by AI, and this piece of art is known as Surya's, and this was generated by an AI system called Raghav, which is an abbreviation for Robust Artificially Intelligent Graphics and Art Visualizer. And this particular AI system was owned by one of good friends of mine, Ankit Saini, who is an IP lawyer based in Delhi. So what he did was he used a couple of his photographs plus this very famous painting of Van Gogh, which most of you would be aware of, the Starry Night, to create this particular piece of art. When he filed for the registration, what happened was he initially filed with Raghav as the author. The Copyright Office rejected that particular application. And then he made a subsequent filing wherein he put his name first, Ankit Saini first, and then put Raghav as a joint author. Very strangely, the Copyright Office granted a registration certificate for that particular work. Again, don't ask me why it granted. The answer is not very clear. But some people thought that, yes, India is making revolutions in this particular area. But many people also pointed out that the Copyright Office is doing it without any kind of deliberations or legislative changes. The net result was, yes, Copyright Office soon realized that it is a mistake. So they said they are going to cancel the registration. But as you can see from the screenshot which I have put here, at least until yesterday, because you can also see when I took the screenshot from the Copyright Office website, it is still shown as a registered work in our registry. It is also not too surprising because the Copyright Office cannot suo motu cancel the registration. They should approach the High Court for cancellation, which obviously they haven't done so far. So what we have ended up with is a fairly messy situation wherein no one clearly knows what is the status. It is also interesting, or it would be relevant for you to understand that the same work was also subject to a US copyright application, but the US Copyright Office had clearly rejected it, saying this is an AI-authored work that cannot be protected under the US copyright law. So the Copyright Review Board also later affirmed that rejection, and that's what you are seeing on the screen. In this regard, it is also important to look at how our parliamentarians are generally viewing this. So one of the documents which you could possibly refer to is a 161st report of the Parliamentary Standing Committee, wherein you will notice that it says, moreover, the huge benefits of AI and its applications in India's revenue generation and economy, as well as its impact on technological innovation, necessitates its expansion in a secured manner. In view of this, the committee recommends that a separate category of rights for AI and AI-related inventions and solutions should be created for their protection as IPRs. It further recommends that the department should make efforts in reviewing the existing legislations of the Patents Act 1970, Copyright Act 1957 to incorporate the emerging technologies of AI and AI-related inventions in their ambit. So this came in 2021, and as most of you would be aware of, we haven't really done anything on that front. So we haven't done a comprehensive review, that's point number one. We haven't also created a new category of rights. Thankfully, sometime earlier this year, one of the members of the parliament had also raised this as a question to the minister, whether the current regime is equipped to deal with AI-generated works. Interestingly, the minister gave a very nice answer. So there they said the existing law is sufficient to deal with this. It is also interesting to see the way they frame the infringement-related issue, which we will see later. So if you look at the first part of the second paragraph, it says, the exclusive economic rights of a copyright owner, such as right of reproduction, translation, adaptation, etc., granted by the Copyright Act 1957, obligates a user of generative AI to obtain permission to use their works for commercial purposes if such use is not covered under fair dealing exceptions provided under Section 52 of the Copyright Act. What does that mean? Are we allowing commercial uses or not? I leave it to you. But one of the ways in which I would interpret it is commercial uses are permitted provided you can prove that it falls within Section 52. So they have given us some leeway in terms of interpretation. Whether this is the correct approach or whether we should have an absolutely clear approach like the US Copyright Office is something which I would leave to you. But yes, this is where we are. Let's also now quickly look at the status of the infringement related questions. So, because that's the second question which I had highlighted. Now, to the best of my knowledge, we have around 32 litigations relating to generative AI in the United States. So the last one which I could find was the one filed 2 days back by the author Christopher Frankfurt against Meta. So 32 litigations are happening in the United States. For most of the other countries, it's not easy to track the numbers, but at least in the case of United States, we have some data. Then, yes, out of this 32, there are also litigations like the Getty image, which is suing Stable Diffusion for copyright infringement, and you will also see there the 2 images which are part of that particular filing. Then yes, some of your favorite authors like John Grisham and so on also have sued OpenAI. Again, that's a class action. And a relatively less known litigation, but which should be of substantial interest for the law students as well as researchers here, is a litigation initiated by Thomson Reuters against Ross Intelligence. So most of you are aware of Westlaw, right? So in this particular case, Ross Intelligence used the head notes of Westlaw to create their own chatbots or AI system. Now the question is whether that use constitutes infringement. So that's a relatively less known one, but to me, one of the most important ones also. Then, of course, many of you are also aware about the New York Times litigation. Again, in the case of New York Times litigation, what is most striking is the fact that they are able to show through evidence that when people are querying specifically, the system can generate articles in verbatim. So many of you might have faced this struggle as part of your day-to-day research. So if you want to access New York Times, you generally have to pay subscription fee. But if you are a smart prompter, according to this litigation, yes, you will be able to retrieve different parts of the article, if not the full article. Again, maybe at least in my knowledge, this is the case law that has shown maximum evidence with respect to the question of whether verbatim reproduction is possible. So earlier we could see similar reproductions, but in this particular litigation, if you look at the case filings, the related documents, you will notice that New York Times has been able to pull out like verbatim copies from many generative AI tools, which also makes it a slightly stronger case. Of course, some people have also pointed out why it is happening. It is happening also because of the so-called memorization problem. So if there are multiple copies of the same article existing in different repositories, there is a very high chance that there will be memorization within the system. So the chances of it reproducing verbatim will go up very highly. So that's also a reason why many people are able to reproduce works like Mona Lisa in a relatively easier way as compared to the works of less known artists. But what is important for us to understand is that yes, currently there are 32 litigations in the United States, and none of them have like reached a proper conclusion. All these litigations are at different stages. To the best of my knowledge, the Thomson Reuters one is the most advanced one. So they were supposed to start the trial last month, but then at the very evening of that particular trial, the judge decided that he will give one more chance to submit documents for a summary judgment. So that trial got, I do not know whether I should use the term cancel, but it has been postponed. And again, I'm clarifying on that because yesterday or day before, the judge has now given them the deadline for hearing. I think it's December 5th and 6th with respect to summary judgment. But along with that, he also said, let's block 5 days for trial because he is also kind of anticipating that things will move to trial early next year. Then yes, with respect to UK, you will notice that the House of Lords Committee has again expressed concern with respect to how the works of different people are used without authorization, and UK is still debating on how to address this particular issue. Again, it's a good idea to look at our neighbor to see how they are dealing with infringements. So the most interesting case in this regard is SCLA versus Guangzhou AI company, which this is a decision from the Guangzhou Internet Court in 2024. So here, again, some people were able to reproduce the characters which you are seeing on the screen. And in this case, again, you will see the pragmatic approach that is being taken by the Chinese courts with respect to this issue. So if you look at the translated part here, you'll notice that the judge is saying, yes, this is an industry which is still in an early stage. So let's not like impose too much of punishment on them. Yes, they should stop infringing the rights of those people. And we will also grant them damages. But again, if you look at the amount that has been given as damages, it's not a very substantial amount. So what we are seeing is the Chinese court taking a pragmatic approach to protect the local industries in this particular case. Now with that, I see that I have only like 10 minutes left. Let me quickly present 5 ideas for our country. So I must also say that these 5 are not distinct ones. They are also very much interrelated ones. So the first one is that we should take a wait and watch approach with regard to copyright ownership question. Again, I am re-emphasizing on this because there is enormous pressure now coming from the side of the industry to grant copyright protection for AI-generated works. And the Surya's example, which I showed earlier, is just one of them. Of course, in the case of Surya's, Angitsani just wanted to test how the copyright system is working. But I wouldn't be surprised if many people also start claiming copyright ownership over works that are generated by AI. But what we might, as a country, want to take is a slow approach. We shouldn't grant into rushing copyright ownership over AI-generated works, particularly works that are autonomously generated by AI. And I'm saying it for 2 reasons. So one, if you look at the existing theories of IP, as many of you would know, there are like 4 major clusters of theories that justify the grant of copyright protection or that educates us on how to modify the copyright system. none of them support grant of copyright protection over works that are generated by AI. So if the theories are not supporting, because all the theories are human-centric, so it's not too surprising, we shouldn't make a hasty decision. The second and related factor there is that at least as it stands now, we haven't seen any empirical evidences that tell us that incentives for creativity are getting hampered because there is no copyright ownership. So if you really have to justify the grant of copyright protection for AI-generated works, what we might want to seek is also strong empirical data that suggests that unless and until there is copyright protection, there will not be sufficient incentives for creativity in this particular area, which, as I indicated, currently doesn't exist. The second thing which you can also consider in this particular regard is, yes, how more advanced copyright jurisdictions like the United States are treating this issue. As I mentioned earlier, they have re-emphasized the fact that copyright law is human-centric, and for works that are generated by AI, there cannot be grant of copyright protection. But what they have also additionally done is strong disclosure norms, and that brings me to the second idea, that is, we need to evolve strong disclosure norms in this particular area. So there are two examples which I want to show in this regard. One is to look at the EU AI Act. So as most of you would be aware of, the most comprehensive legislation that exists today with respect to artificial intelligence is the EU AI Act, which was recently passed. Of course, it would take another maybe 5 years, because I think that's the time period which they have 5 to 6 years to get it fully implemented. So there are certain things which have been clarified through EU AI Act. So one of them is that there are transparency obligations with regard to some of the AI systems, particularly those that generate synthetic content. So with respect to the ones that generate synthetic content, now, yes, they have to tell to the potential viewers or readers that this is a content that is generated by the AI system. And one of the examples which is specifically mentioned in the EU AI Act is watermarking. So that's something which we can consider. So if a particular piece of music or if a particular piece of artwork is generated by AI, the minimum we should demand is that the public should know that this is a work that is generated by AI. Of course, watermarking is mentioned as just an example there. There could also be many other ways in which we can do that. The other important thing which the EU AI Act has done is they also say that there should be a detailed summary about the content used for training. Again, what is the meaning of summary, how detailed it should be? These are things which we should wait and watch. But at least the EU AI Act has taken one step in this regard by demanding that there should be a detailed summary about the content used for training. Similarly, if you look at the United States, at least one good thing which the US Copyright Office has done is that if you have used generative AI tools for creating content, and if you are seeking registration, you have to also disclose how you have used the generative AI tool. And depending upon the disclosure and depending upon the human involvement in the creation of the work, the Copyright Office will be able to take a decision on whether that work should be granted registration or not. The question which we might want to again then ask ourselves is, have we done anything in this regard? The clear answer is no. So this is the second point which I wanted to make. So maybe, yes, we need to evolve strong disclosure norms in this particular area. The third one is to introduce a strong text and data mining exception under our copyright law. So here again, I would draw your attention to a very recent decision from the district court in Hamburg, Germany. So this litigation was relating to the Lion 5B dataset, which has been used by many of the generative AI tools for training. So here, if you look at the facts, you will notice that what they did was they used a pre-existing data set from another source, that is Common Crawl. And that particular data set had links to approximately 6 billion images. So what Lion did was they downloaded all those images and then checked whether the images are matching with the description of the image that is provided there. So in other words, yes, they are trying to actually draw inferences as to whether the image is matching with the description of the image provided. Now, one of the photographers whose work appeared as part of the data set sued Lion in a German court for copyright infringement. And they made the argument primarily based on 3 provisions of German copyright law. So one was relating to the question of whether this should be just treated as a temporary act of reproduction. The court rejected that, saying, no, that's not the case, because Lion actually downloaded the works and then did this analysis, which means that exception provision is not applicable. The second one was the question of whether this can be treated as text and data mining, and that was section 44B. And the third one was section 60D, that is text and data mining for scientific research purposes. So you might be wondering, why do we have 2 different provisions, section 44B and section 60D under the German copyright law as an exception for TDM? The difference is that, as you may notice, 60D is specifically with respect to scientific research purposes, and there are no exceptions to that exception. Whereas with respect to 44B, there is a categorical exception which says that if the concerned authors had opted out their works from training, then those set of works cannot be used for training. So in this particular case, it was a mix of works wherein both the disclaimers existed saying that this work should not be used for training purposes, plus list of works wherein there was no such disclaimer. And with respect to this particular photographer, there was a very specific note associated with that work which said that the work should not be used for training purposes. Thankfully, the German court said that section 60D of the Copyright Act will be applicable in that context, because according to the court, this kind of a training purpose fulfills the requirement of research purposes. So again, the photographer tried to make the argument that there are commercial interests involved here, because a lot of Lion's work is sponsored by different generative AI tool companies and so on. But the court rejected that by saying that creation of a data set like this is very important for the purpose of knowledge gain. So what has happened through this particular litigation is the establishment of the fact that a proper text and data mining exception is very, very relevant in the context of generative AI. Of course, I must also very categorically add here, the court didn't address the question of whether or not the training of AI as a whole is subject to the limitation or the exception provided under the Act. That's a question that will be addressed later. As it stands now, the only question was whether the data set, that creation of the data set is a violation of the rights of the copyright holders. So in the Indian context also, if you really want to advance in our AI-related research, one of the things which we will have to do is to have a proper text and data mining exception. So that was the third point. Fourth point, we also have to enable opt-in or opt-out. So on this screen, you will see a contract that was recently sent to me by the Cambridge University Press. So I have, as the person who introduced me was telling, one of the books of mine was published by Cambridge University Press, and a couple of days back, I received an email from them saying that here is an addendum, please go through it and then sign it if you would like to. So when I'm going through that, yes, this addendum is talking about allowing the use of my book for training purposes. And if you look at the question, what will happen if I don't sign the addendum? What the Cambridge University Press is telling me is that if I don't sign, my work will not be included as part of the training purposes. So that's the approach which they have taken, which means what they are following is a kind of an opt-in system, because unless and until I say yes, they are not going to use the work for training purposes. It is fine whether we want to go with opt-in or opt-out, but what is most important is that maybe we as a country need to take a position with regard to which approach we want to take. Do we want to have an opt-in approach, or do we want to have an opt-out approach with respect to allowing the use of the works for training purposes? In general, my inclination is more towards opt-out, because many a times it is very hard to find the authors of a particular work. So demanding opt-in would mean considerable limitation in terms of the corpus of works which are available for training. On the other hand, if you have an opt-out system, those who want to opt out can opt out, but those who don't bother about it, yes, their works can be used for training purposes. So in general, I am very much in favor of an opt-out, but yes, the broader point which I want to convey as part of the fourth idea is that we need to have clarity with respect to this dimension. The last point, and maybe the potentially the most controversial point which I also want to suggest, is we may want to make some minor tinkering in our law and move from fair dealing to fair use in section 52(1)(a). So as most of you would be aware of, the most important differentiation between fair dealing and fair use is the fact that fair dealing is limited to the specific purposes mentioned in section 52(1)(a), whereas fair use is a purpose neutral exception. So my suggestion, and again I know this is a fairly controversial one, is that we can actually fine-tune the language of 52(1)(a) and then turn it into a fair use exception. And the specific suggestion I have is, of course, we have to change from fair dealing to fair use in the initial part. But on the last part of that sentence, instead of for the purposes, we can say purposes such as, and then list these purposes. That way, the advantage would be that we will be able to make our section 52(1)(a) a purpose neutral exception, and the judges will have considerable discretion in terms of deciding, of course, based on the facts of a case, whether it should be allowed or not. I also want to emphasize that I'm not suggesting a complete shift to the fair use here. I want the enumerated exceptions to be retained and even further enriched. So that's the reason why I earlier mentioned that, yes, we need to also bring in a text and data meaning exception, because that brings in enormous amount of predictability in adjudication. Because for a judge, it's far easier to read an enumerated exception and decide whether something should be exempted or not. So that's the reason why I would say that what we should do is only tinker with 52(1)(a) and retain and further enrich the remaining provisions in section 52. So these are the 5 suggestions I have, and I just wanted to also end my presentation with the observations of Judge Bibas in the Thomson Reuters case, which I mentioned earlier, because that's a dilemma which the entire world is currently facing. Because when it comes to the question of whether these kinds of, say for example, allowing the use of copyrighted materials for training purposes should be allowed or not, one of the most important challenges is in what direction the public benefits dimension will swing. Because on one side, yes, we want to protect the interests of our artists. On the other side, we also want to further promote innovation and creativity in our country and across the globe. So if you read this Thomson Reuters judgment, yes, towards the last part, you will see this dilemma, which is very, very nicely described by the judge. And then, yes, he says, so a judge must decide the 4th factor and the ultimate conclusion on fair use. And I think that's a dilemma which I also, as a researcher, has on this issue, but I hope that at least the 5 ideas which I suggested through this presentation will address us to stay afloat till the time we have more concrete answers on these issues. So with that, I end my presentation. I do not know how much time we have for Q&A. 10 minutes? Okay. And I very much look forward to hearing your thoughts on this. Thank you.
Good morning, sir. Myself, Sita Lakshmi. I'm from KUSAT. Sir, my question is, Article 22 of GDPR says that essentially we need human intervention, right? Again, AA Act also requires for high-risk AA system, we need human intervention, but then, or essentially oversight by natural persons. So my question is, when it comes to copyright, we have a very basic or very low intensity, classification of originality.
Yes.
So, for example, if you assume require just human, originating from the author as the basic criteria for originality. So these AI, I believe all the AI are basically trained by humans, which later on becomes more advanced, and whereby the AI creates, like we see, creates on its own. Essentially, an AI is originated from a human through human intervention, right? See, like humans, we have an innate intelligence, unlike an AI which doesn't.
Yeah.
So this human intervention criteria that AI Act or GDPR says, couldn't that be? Is it similar to originality concept that we have in copyright? Or is it necessary that we should have a sort of copyright intervention for AI and human?
Yeah, thank you for that very interesting and I would say very difficult question. So, couple of things there. So, one, for the benefit of everyone who is here, we are not familiar with how the EU AI Act works. So EU AI Act is taking a risk-based approach wherein, at the top level there are these so-called prohibited activities. So there is absolute prohibition on that. Then, yes, as she mentioned, there are the so-called high-risk activities. And then there is a so-called general purpose AI, wherein they say that there will be a subset called works that are having or purposes that are having systemic risk. So if your activity falls into the high risk activities or a general purpose AI with systemic risk, then human oversight is a mandate under the EU AI Act. So that's a fairly strong one, and again, we would see similar approaches with respect to GDPR also, which is a privacy protection legislation in the EU. Is that the same approach which is being followed in copyright law? My answer would be no, or at least that would be my inclination. The reason being the kind of human oversight which is expected in those instances are at a fairly high level. Now, when it comes to the question of originality, again, even with respect to, forget about the machines, even with respect to human authored works, as at least some of you would be aware of, originality is not examination. In other words, you file something, they immediately grant you. Whether that's a valid one or not has to be adjudicated by a court of law. So we cannot then use DABAS as an example here. In the Indian context also, thankfully, I think this is also something which I should specifically mention, the patent office had the wisdom to clearly give an objection when DABAS filed the application. So they haven't taken the final decision, but the initial first examination report, if you look at the first examination report issued by the patent office, it's a well thought out one which says that under the current provisions of the Indian patent law, we cannot grant you a patent. So DABAS would be a bad example to.
Yes, sir, that is the Stephen Stellers. He applied at the international level, but even the particular commissioner also rejected this kind of thing. But that particular above federal court.
What I'm pointing out is that yes, Stephen Taylor's efforts to get patent for DABAS has failed in every jurisdiction except South Africa. And in South Africa, it didn't fail for a specific reason, which people are conveniently forgetting.
Can I find a source of this kind of thing? On
7,
Hello.
7, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 38, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65. These are all there. I can see hands. No, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, yeah. Oh, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 2, 3, 4, 105, 106, 107, 108, 109, 110, 111, 12, 113, 114, 115, 115, 116, 117, 118, 119, 120, 121, 122, 123, 25, 126, 27, 128, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 145,
all the participants who haven't joined their respective venue WhatsApp groups yet, please do join at the earliest. Thank you.
All the participants whose attendance was not called, please come to the front. The participants whose attendance was not called, please come to the front.
Can everyone please settle down? Thank you. I request everyone to settle down ASAP so that we can proceed with the session. Ladies and gentlemen, we are thrilled to present our next panel discussion, The Flow of Money in Copyright, Navigating Royalties and Revenue Streams. Conducted at the behest of our wonderful sponsors for this session, Advocate Jijo Cherian and Ms. Apurva Reddy. This timely and crucial topic will delve into the complex landscape of copyright economics in today's digital age, examining the intricacies of how royalties and revenue streams operate and interact. We're delighted to welcome our two distinguished legal experts from the music industry, Dr. G.R. Raghavendra and Advocate Sandhya Surendran, who bring a wealth of expertise and diverse perspectives to this discussion. Our first speaker, Dr. G.R. Raghavendra, is a senior consultant at the Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, and has had an impressive career as a civil servant. He has been a key contributor to legal reforms, including the National Mission for Justice Delivery and initiatives to improve contract enforcement. With a PhD in performing rights and extensive involvement in IP policy and free trade agreements, he's a prominent voice in copyright law. We welcome you, sir. Our second speaker, Advocate Sandhya Surendran, is a distinguished lawyer specializing in media, entertainment, and technology. A 2007 Nalsar graduate, Advocate Sandhya's career spans notably across Infosys, InMobi, and Vice Media before founding Lexic, her boutique legal consultancy, in 2016. She is also a thought leader in the music industry with her podcast, Lex Talk Music, and is frequently recognized for her cutting-edge work with emerging technologies like AI and blockchain in the entertainment space. Together, Advocate Sandhya Surendran and Dr. G.R. Raghavendra bring a wealth of knowledge and experience to our discussion. We eagerly anticipate their insights on navigating the intricate world of copyright economics in the digital age. Without further delay, let's begin our panel discussion. Over to you, sir and ma'am.
Thank you so much for that warm welcome, and thank you to Nuals and the sponsors for having us here. And I think this topic is, everyone wants to know, right? Like, how do you make money off copyrights, especially if you're in the music industry? But given the kind of expertise we have with Dr. Raghavendra here, I think we'll also be touching upon a few other aspects like publishing and in books as well. If you've understood and if you've learned copyright, you know that the 2012 amendment is perhaps one of the most critical landmark moments in the evolution of copyright law. And it's amazing that we have Dr. Raghavendra, who's been a very critical part of that amendment as well. And 2012 amendment played a very important role in monetizing royalty and revenue streams for artists and authors and composers, right? So I'd like to start with that and kind of go into identifying the different revenue streams which come out of the ownership of copyright and who are the people who benefit from it. So for example, in music, you have performance royalties, which are typically collected by copyright societies. You have the concept of mechanical royalties, which is a reproduction royalty. Basically, anytime your composition is played or reproduced, you are entitled to a royalty. So all of these are royalties that are collected by a particular entity, and you have sync royalties, which are direct party-to-party collections. But in addition to these, you have other revenue streams arising in today's era with digital distribution, and how all of this kind of ties into our Copyright Act and how you can, as an artist, benefit from the amendments that have been made to Copyright Act. I think that's something which we'd probably touch upon today. Apart from also looking at how generative AI has kind of come and spun everything on its head, and how that is something that is potentially a new revenue stream for copyright holders, right? Sir, I think I'd like to ask you about the relevance of 2012 amendments in monetizing a copyright holder's right, and especially the performer's right, and also the rights of author/composers to retain certain rights and to also continue to monetize them. What was the thought process behind it, and how is it that, I feel like the industry practice today still kind of goes against those amendments? And I know for a fact that when I negotiate on behalf of artists, I constantly quote and cite the 2012 amendment and say that this is something that is a statutory right. So could you just walk us through that process and what what went behind it?
Yeah. Vande Mataram. Thank you, Sandhya. Again, I would like to thank Nandita Narayan for giving me this opportunity to share my thoughts. You're all young students. While reading the textbooks or any case laws, when they refer to the 2012 amendments, what I suggest is you go to the bill, which is available on internet. Whenever a law student should read a bill, it should go to the statement of objects and reasons. So the 1 page or 2 pager shortly gives what is the legislative intent behind the amendment and what is the philosophy, the economics and the rights protection issues briefly written there. So that is the objects and reasons for introducing amendments, for clarifying the already existing rights or giving a new right. And are these in harmony or in compliance with the international copyright system? So various WIPO administered treaties and conventions, which India is a member, or India may not be a member, but those international law which implemented Indian law, how it is going to help Indian stakeholders. The major problem, as I explained, those who attended my talk yesterday evening, it began from a Supreme Court judgment in 1997, that is Indian Performing Rights Society, IPRS, versus Eastern Motion Pictures Producers Association, is a 2-judge bench, Justice Jaswant Singh and Justice Krishna Iyer. But unfortunately, the Justice Jaswant Singh wrote the judgment, and Krishna Iyer was sitting in the back seat. He wrote only obiter dicta. But that obiter dicta inspired us, after more than 20 years, introduced this amendment to clarify the rights, what are exactly the performing rights. But we also did one mistake, but not defining the term performing right. By not defining the term, it is giving an opportunity. Still, the problem is like that you enter a mall, there is a shopper stop or your favorite, garment, shop is there. You buy a shirt. Shirt value is 1,699 rupees. Okay, you bought it. Then you say that I am paying to the shirt. Why should I pay for the tailor? Why should I pay for the weaver? Or why should I pay for the cotton growing farmer? But then I am paying once, that's all. So music rights, it's not like this. Just like just now Sandhya said, music right, there are various kinds of rights which has been recognized right from the Berne Convention, which is included in the TRIPS Article 9.1, from Article 1 to 22 or 21 of the Berne Convention, including the appendix. Appendix finalized in the Paris in 1971 and revised in 1979. The appendix about the compulsory licenses, basically, for the reproduction and translation, the works are not available. So, what are these music rights? She said, performing right. So, unless and until this is properly clarified, there are authors. Who are the authors? Like yesterday I was mentioned with Guljar or Javed Akhtar or any songwriter. song starts, whether it is a Malayalam, Hindi, Kannada, Telugu, Tamil, Bengali, song lyric has to be written. The lyric writer is an author of that literary work called song. Okay, copyright subsists in that. That is one right. Based on that, another music right, the music composition, the music composer, A.R. Rahman, or you take anyone. Third one is the singer, let's say the sound recording, when it is recorded, the master copy comes when singer is singing, the lyrics accompanied by the music. So already 2 existing copyrights are included in that. Lyrics, right, literary work and musical work in the sound recording along with the performer's performance, live performance. So that is performer, that is again related right. And question came in whether many people, when monetizing starts performer, he said, okay, Sonu Nigam has been invited here, he is singing. So he has performance right to be exploited when he is singing live, but not when a sound recording is played in the radio or any other place. Music companies oppose that, and many other people also oppose that, broadcasters and all that. There is no right and all that. So there is a beautiful case, Delhi High Court, Neha Bhasin versus Anand Raj Anand. Please read this. In this court has clearly said, this has not been challenged in the Supreme Court, my friends. So this is the law. What it says, Sonu Nigam or Shreya Ghoshal for monetizing that, not live singing here. How did the sound recording company record it and picturize that song on Hrithik Roshan and Katrina Kaif and synchronize in the film? Then that is the synchronization right happen. So song is picturized and synchronized included in the film. How it is happening? So here different rights are there. So this should be recognized. And the question comes, music composer, while composing that, he will write some notes. Only guy who knows the music, the raga or the tune, he will know. Whether Hindustani raga or Carnatic raga, that notation, he will, if you see it's a Greek or Arabic or Indus Valley script to you, you don't understand. Only the musicians can understand, read that and start playing, composing music. They know what is Arohan, Avrohan and all that looking at it. What is the pitch? Indian Idol, guys know I want minor, major, all minor, major scales are there. It's nothing but the scales and the song written there, music composition. So that is a graphic right, they call it. That is published in a book sometimes. But even it is published as a book, various composition, let us say Sandhya composes about 100 songs. If that comes as a book, that is a literary work. But that work per se is again a musical work, that graphical. So this difference you should know. Then what happened? In that case, I go back to that case. Jaswant Singh wrote a judgment that even though section 17(1) says first owner of the copyright is the author, but B and C is an exception to that. It says provided that in absence of agreement to the contrary, okay, if there is no agreement, it will be deemed that rights have gone to the sound recording producer or a film producer when it is incorporated there. Finish. So there is a presumption that this guy has to rebut. Okay, I said only this. There is a oral agreement is also there. I'm not given. You will give me this much, and entire rights have now transferred. That kind of contracts or oral agreement was done only by 2 people initially, by Lata Mangeshkar beginningly. She was like a queen. No one could so No, she says, I will not sing in a film. Then the other number 2, number 3 songs would have not been that popular. And even Muhammad Rafi could not manage that, but later times he managed the rights management, monetization. And what judgment said? So it negated that, once you don't have rights, other composers, everything you are going to, film producer takes away. I'll give you a best example of Om Shanti Om. Om Shanti is an open secret. Om Shanti Om, the producers wanted A.R. Rahman to make music. But A.R. Rahman was following the formula of Lata Mangeshkar and Muhammad Rafi. I want this much rights. Signing amount is there. After that, percentage of this from the profit. But who is the music company? Producer will further sell. He was she. Who is the Om Shanti Om producer? Farah Khan. She and other person, they were selling, they already wrote an agreement, signed with the T series. T series said, aapko 15 crore de denge. 15 crore decided that time. Huge money. After that, Farah Khan, one time she will take, and T series will monetize. Whether releasing CDs or, radio or TV or whatever, digital medium, everything they make money. When this guy is asking profits, so they said, usko nikal do. Remove A.R. Rahman. We don't want. Because money is a big thing, no? 15 crore. Farah removed A.R. Rahman. She bought Vishal Shekhar. Vishal is a good friend of mine, Vishal Dadlani. So, Darda Disco. It's a Darda Disco for A.R. Rahman. And the Oscar winner has to sit in the back seat. He lost the money there. These guys made money. So this is called the commercial monetization. Finally, Krishna Iyer writes in the Obiter Dicta, the Obiter Dicta, unlike a footnote in the international treaty, or agreed. How many of you are aware of agreed statement? Have you read a WCT, WPPT treaties? Yeah, there is an agreed statement. Means it's a footnote, because sometimes it's just like an explanation in the Bare Act section. Do you think that only section is legal, explanation is not legal? Yeah. It is legal. It is the same agreed statement as value. That's what Vienna Convention of Law of Treaties 1967. Read this. In this, Article 31 explains that how to interpret the treaties. Read the preamble, read the article, read the agreement, agreed statement. All have the same legal value. It is the interpretation of treaties. It is explained. So that legal value is not given to Obiter Dicta. A footnote hi rahega. So unfortunately, he should have written in the body, but he didn't write. He gave it to, a rumor is that Jaswant Singh Sanila from sound recording industry, sorry, film producer, not sound recording industry, so his rights to be protected there. That's why the judgment went in his favor. Apparently. So it's not mine, what I heard.
Sir, should we be saying this in public?
So then what happened, Krishna writes that, in a penumbral area of umbra penumbra, when eclipse happens, penumbral area of policy making, government did ignore these people, authors, composers, and even performers. When I was a boy, Sholay was removed, Sholay came. And at the time, a cycle rickshaw with a gramophone used to come with a mic. Song used to be played and he used to announce. He said in that it is a commercial exploitation. Yeah. Inviting people to come and see film, buy a ticket and see in the film. And you go and buy a ticket and sit just like this. Empty screen is there, film will start in another 5 or 10 minutes. and then he will start playing songs to entertain you. Then that is also commercial exploitation. Then how you are all this allowing for all these things? They should get royalties. That's what they are asking. Yeah. And you say that a song is included in the film, rights has been totally assigned, is gone. If author-composer problem to be solved, Naushad, yesterday I told you, signed an agreement on behalf of author-composers with the music companies. We'll share 50-50 the international model. But this was not agreed to in letter and spirit or implemented letter and spirit. Many people suffered. The big people also suffered, like Javed Akhtar and Guljar, many others. And we brought the amendment in the Rome Convention, Article 12, where secondary rights are there. Secondary rights clearly explain if it is not working, the national law can introduce sharing of percentages, which is the international model approved by the WIPO. 190 countries following this. If it is not working, we thought that we'll write in the law. Equally share 50%. Yeah. No, there is a body called Performing Rights Royalty, called CSAC. Confederation of International Performing Rights Societies. 126 countries, more than 130 PRS societies are there. They wrote a letter saying that is the best thing India has done introducing this. Other countries should emulate this. And finally, another letter came from, at the time, Krishna Iyer sir was alive. He wrote a DO letter appreciating to the then minister, HRD Kapil Sibal, saying that, you woke up after 20 years to set right the thing. What Parliamentary Standing Committee writes that, they also write after 20 years you woke up like Ripvan Winkle to correct this. So everyone appreciates. So then monetizations are. But there was a problem for the performers. If you see, there is a provision giving performer rights in the Rome Convention where performer rights started. There is a cutoff provision. Again, similarly like this. Here, it is not you assign or absence of agreement contrary, or there is an agreement. Still, you can't, in agreement, you can't say that I will retain my rights beyond the film. No. It says once singer sings song, incorporated in the film, synchronized in the film, his rights are gone. Sandhya, you take one-time payment of 1 lakh for your song, sing and go. If I exploit in my film your song, you will not get any. That's what the cutoff provision is called, infamous cutoff provision. So no cure for that. We cured it in the amendment. Yeah. We were inspired by the concept called single equitable remuneration. Yeah. We did not borrow this comment and include it. They said right to receive remuneration, they call it. The EU law. We said right to receive royalties. Reason why I did not say remuneration, because all big singers and other composers said, we are not begging. It is our right to receive royalty, not remuneration. Yeah. Then what is the concept that single equitable remuneration introduced in the Berne Convention 11 bis first time? It says that a singer sings a song, when it is exploited in the broadcasting, so at least single equitable remuneration. What is single equitable remuneration? Again, coming to different rights. There is the performing right, where sound recording company will get 50%, and then sound recording right, they will get 100%, and performer right, they will also get 50%. So why you should take different royalty and licenses? We make one payment, single equitable payment, one performance of that song, and these people will split. So on this basis only the single window is coming in India. So the thought has occurred, and the industry is working to introduce that. So in amendment to, when we introduce the amendments, we strengthen the performer rights. While retaining the cutoff provision, we said, okay, his rights are gone totally when it is in the film, when you showing it the cinema hall. But any other commercialized just like other composers. So royalty banti hai. That's what
So
we have done.
performance royalties.
Yeah.
But
so,
again through a copyright
yeah,
society.
yeah, through a copyright society. That's why we facilitated registration of ISRA first.
ISRA, yeah.
There, and their problem happened while before registration, people gave applications like Nandita is a professor, Sandhya is a lawyer, and one singer. Like this, 7 names they came, registered this. How come? All are performers. I said singer is a performer, a tabla player is a performer, flute player is a performer. I understand. They are all musicians. How come a lecturer, a lawyer, sir, lecturer giving a lecture is a performance, she is a performer. Lawyer standing on the legs arguing before the performer. Then okay, I register a society. How will you? Well, when Sandhya is going to, if you post all your in the videos in social media, then are you getting some royalties? Are your lecturer getting royalties? How it should be done? It will disturb the performers' royalties and the tabla player royalties. Then we said clearly in the rules, no, each class will register separately. We did not say, because any definition says that any performance, any other performance is also a performer.
Is also a performer.
So
correct.
if they want to imagine lecturer as a performer, lawyer as a performer, let all academia consider copyright society. If their videos are being exploited, educational levels, you have a collecting society, you collect that.
Correct.
You lawyers, you have your own collecting society, collect that. Why you want to become a parasite on singers?
Singers, yeah.
We removed that.
On the musical side,
Yeah.
the singers.
And there is a question came whether the helicopter shot of Dhoni, that is the performance.
Yeah.
The question came before the Delhi High Court, before the matter came, many advocates rang me up, sir, ye kya bataiye? Why it is not defined there? And, if you want to bring that category, any other performance, up to you. But that did not work, it stood there. So the law as stands now, totally harmony with the Rome Convention, despite India is not a member, is in harmony with the Berne Convention, of course, that is the mother of all copyright treaty, international treaties. Then came the technology development, internet. Internet 1.0 came. 1.0 only with a static interaction before 90s. So there will be a website, there will be some content, some photographs and all that, no interaction. But late 90s, the web 2.0 came. It facilitated interactivity in internet. Like it gave rise to YouTube, it gave rise to various platforms, social media platform like Facebook, Twitter now it's called X, and various blogs where you may have your blog, where I'll go and start writing my articles or comments, something. So this became a big issue, digital. So rights, and people started electronic commerce, selling books,
Pirated books.
When it is delivered at your home, you may pay physical copy, but online you make payment and download a digital copy, read it in Kindle. Then Kindle came at the time. So and all pirated versions started coming, books also. It became a big problem, and that's why treaty came. And when WTO was being finalized, TRIPS was finalized, many countries said that let us include digital issued in the copyright in the TRIPS. But other countries said no. It took 40 years to finalize, come to Marrakesh from the Uruguayan round. We can't delay much. Let digital issued be covered by the WIPO, which is a special body. There is a standing committee on copyright related. Let them handle this. It was handled. In 1996, the WIPO Internet treaties came. WIPO Copyright Treaty 1996 extended the physical protection protection given to physical copies in the Berne Convention to Internet, Web Copyright Treaty. Similarly, Rome Convention gave physical copy protection for the performer's right and sound recordings and broadcasting to the Internet, WPPT. But WPPT gave only oral recordings, not the audio-visual recording. The audio-visual market, the monetization models differ from the US, EU, India, and other countries. There was a big fight. They decided to, instead of fighting, because there is a tearing hurry to introduce internet protection, at least we'll take our audio part. There's WPPT, the WIPO Treaty for performers and phonograms. That's only oral. The Beijing Treaty came later.
So how does this impact streaming revenue, sir?
Yeah, streaming revenue, coming to say that they use the technology there, they protected the circumvention technologies. Internet facilitated that your songs will be downloaded and bought all over the world, not only India, not digitally, but people started doing piracy, unauthorized uploading and downloading. To top that, they put encryption devices. There is a access control and copy control. But people de-encrypt it. During COVID times, everyone subscribed to Netflix, Amazon Prime. For your TV, 499 rupees, your mobile, 199 rupees. And you paid happily. But can anyone raise a hand that who hacked this encryption and not paid the money and freely watched?
I don't think anyone's going to admit that here.
No one. No one. So, and what this technology provides, you download, you can watch on 2 devices or 3 devices. When you are not only on TV, you can watch here. But you to take 199 mobile, you will watch around 1 mobile or 2 mobile, like that. Not on the TV. But you hack this. You take 199 hack and put on TV. So this is illegal. So there is a criminal mens rea here introduced WCT, WPT. India 65 way also we introduce mens rea. Knowingly doing this will impose a fine, hefty amount fine, and also 2 years imprisonment. And also there is a rights management information. People remove the name, title, copyright information. Metadata, that also metadata. So fine. And then streaming issues you're asking. So all these things are applicable to streaming. So copyright, performer rights, music rights, sound recording, everything applicable. When streaming happens, so let us say the any song is there. Your favorite song is 3-2 ka song, I think nowadays famous. 1 item number, Tamanna Bhatia. So somebody, before it was uploaded, then I came to know yesterday only. Till then I didn't know that such song is existing. And people going gaga over that. And if that is uploaded by one guy unscrupulously on streaming, YouTube, immediately we introduced the concept of safe harbor from Digital Millennium Copyright 1998 from the United Nations. That is not safe harbor. Safe harbor is not touched. Internet service liability is not touched in WCT WPT.
So intermediary liability is basically your
not there in WCT WPT, not even the Beijing Treaty. US covered it in Digital Millennium Copyright 98. We borrowed that and put it in section 52(1)(c). We gave 21 days time to YouTube. YouTube says, I don't know who owns the copyright in T-series or tapes or someone. So let him come. And this guy who was uploaded that I am the owner. How would I know? So T-series has to run to Delhi High Court, get an order. It's not an easy.
It's not easy.
So we gave 21 days. So 21 days, think these people is allowed, their money is gone. So after that, he gets an order. There's a two-way process. He may legalize this, and he will not pay to the. He will keep the pendency not pay to you if you are unloaded. The moment he got an order and evidence, so the payment ad revenues are there, everything will be given to you as per the agreement signed.
Oh, that's pretty much the model they follow with YouTube now.
And even after the order, the guy who has uploaded illegally is insisting that it's mine. He is not removing. Then the fine will be hefty on YouTube. Then there will be vicarious liability will be there.
Okay.
So he will suffer. Then so there are two models basically in the streaming revenue model. One is, how many are subscribed to Spotify or Hangama or Wink and YouTube?
Wink is no longer there, but
so only few subscribe. You subscribe it because you don't want advertisements to be seen.
Correct.
Okay. So then you pay monthly 100 or 200 rupees. That money is shared between the right owner. Whether IPRS is there, performing rights share with them, performers share with them, sound recording, all the rights owners are shared. With that subscription money. But free people are many. What happens? But nothing is free. Like FM radio, you are driving car listening to Radio Mirchi or some other. But how they make money? In between advertisements are coming. Similarly, YouTube also putting advertisement, Wink advertisement, all these ad revenues. The ad revenues because you buy Swiggy ad is coming. Swiggy fellow will give some money to that platform owner. Okay, put my advertisement here because a song, the Tamanna Bhatia song must be clicked some 40 lakhs or something. I don't know. Everyone clicks down, see that ad, go for Swiggy. At least some percentage will order for Swiggy food instead of Zomato. Because Swiggy is getting registered him. Chalte Swiggy try karte. So that his business, then that is not given freely. He will be charged. That is put in the advertisement. That revenue is getting will be shared with some percentage shared with the copyright owner of that particular song. It goes on like that. And sometimes the model don't work. Ghana failed. And they have to close the dukan. Then they came back with the subscription model. They still are crying. Then they said when the statutory license, I'm just coming slowly.
I have so many questions.
Statutory license came, and why it was introduced? Actually, there is a compulsory license. There is a voluntary license. So you run a FM radio, you have to play songs. That is the main content. For playing songs, you have to get a IPRS license, performing right. You get a sound recording license, PPL. You have a singer's license from ISRA. ISMRA. So negotiations, there is a problem. The tariff scheme so high, you are not able to meet. And if it is too high, Copyright Act clearly mentioned there is a section, if I'm correct, 35, tariff scheme of Copyright Society. There it is written if the user thinks that tariff rates are so high, you can challenge that tariff rate in the court. But till decision comes, you should keep paying that. Okay. Then, if still it is not helping your economies of scale, and he will then say, if you don't pay this, the court has approved this thing, still you have to pay. No, I can't pay. You reduce it, I will not reduce. So not reduction is treated as rejection. Because if you play, it is an infringement.
Correct.
Even though you are a CEO of Radio Mirchi, criminal case will be filed against you. Only file supporting your right owner. You file for injunction, you file criminal to threaten him, come in the line. He said, hey, kya ho raha? It has been denied. If I use without license, this will happen. He will go and seek for the compulsory license. Compulsory license, you have to give evidence that negotiation held on such and such date, it was denied, didn't work out. Please give me compulsory license. That is section 31(1)(b). And then court, earlier Copyright Board, later IPAB, now the Delhi High Court for Delhi region, Kerala High Court commercial bench for the Kerala region, Bangalore High Court commercial bench for the Bangalore area. Similarly, Chennai, any 25 High Courts, their jurisdiction, this case file can be filed. Then they will decide, adversarial, both parties will come argue final decision on the basis of what is the commercial market rates existing. Again, on that basis, rate will be fixed by the court. But this will take some time. And then in the meantime, she is an intelligent lawyer. To delay that, she will file a miscellaneous application. She knows this drama. So, on miscellaneous action, sir, I have not got a copy. Okay, next date. Then I will file a reply to our miscellaneous, sir, I didn't get a copy. I just received, sir, I have not prepared. Please give me adjournment. Okay, given.
This will take forever, basically 25 years.
This goes on. She knows all this. This drama happened right before me. As a registrar of copyright, any objection comes, senior advocates used to come. They have to argue in the same style more than 1 year, many cases, more than 1 year. One day I said, I am going to give an order based on the merits. What you have submitted, you both sides are doing drama. Both advocates got together, he said, we'll go, okay, aap likh do, hum high court mein petition dalenge, you didn't hear me. But you're doing drama. Now you're not cooperating. Then I pity at your clients sitting backside. अरे भाई आप लोग तो प्रेशर डालो, मुझे कोई बेनिफिट नहीं है. Now you people come and waste my time every time. I have to leave important meeting and sit in the hearing because given a time, and you come and do this drama, take another date and go away. And after I give convenient date, after discussing, I am giving not my date, your convenient date, both agreed. On that day you again come to do drama. 6 months have gone now.
I mean, it's actually quite, it's embarrassing that as a lawyer you have to admit that.
Tariq ke upar Tariq, don't blame the courts many times. And parties were also smiling because
that's a negotiation tactic.
So, and who are the parties? Both brothers. Blood brothers fighting this thing for some artistic work. So, going back to the same thing, time? Okay. So, statutory license came because to help the fledgling industry, FM radio only. Then TV came. We introduced, radio and TV. Then internet came, streaming guys. Allow us. No, act has been approved by the parliament. The rules should be made. I mean, tell you, the rules were drafted in the very city, Kochi. The committee thought we should not get disturbed. There is one professor, N.S. Gopal Krishnan from Kusat, now retired. So he was the member. We asked them, sitting in Delhi, people disturb us, don't allow us. We want to drop this secretly. Then you come to Cochin, sit in Kusat, you draft. So entire committee, we came and sat in Cochin, Kusat and drafted the rules, 2013 copyright rules. Then we did not give anything for the internet. Now by mistake, the ministry issued an order, the broadcasting is by any means allowed internet. They did not read the subsection 3, which is a non-abstentive clause, an exception to the 31D subsection 1.
Correct.
So that is the mistake they did. It was struck down by Bombay High Court. That notice is wrong. So recently, officially, we have withdrawn from the ministry. So these are the things. Next, artificial intelligence is coming. Now, artificial intelligence is composing songs, writing songs, singing songs. Other day, somebody, sent me a video, Narendra Modi ji, Honorable Prime Minister, singing a Mukesh song. Same voice is, sir, Prime Minister, sir, the song is Mukesh song. What is this? So, and tomorrow you're going to monetize this? I know there's a question of personality right will come. And then somebody is creating a new song using Sonu Nigam and Shreya Ghoshal without, they don't know that they have sung this song.
Yeah.
The song is released, mimicking their voices. And sometimes what happens, now the Web 3.0 is coming. Web 3.0, there is a metaverse, Facebook Meta, they renamed as Meta, you know that. There is a metaverse. Metaverse, there is a virtual reality, extended reality, mixed reality. In this, either Sonu Nigam can go and give a performance. Recently, Taylor Swift, she gave a performance, online performance, using the Meta. That what is the beauty of the Meta is she is sitting in the drawing room and giving a performance. All over the world, people, that virtual reality feeling is coming. She is as if singing not in a drawing room, but in your drawing room. Okay. And then you can ask a question, Taylor, please sing this song. Okay, I'll sing this. Do you think this will happen in a stadium in Kochi when Taylor Swift comes? Impossible. Lakhs of people are finished.
I think
so. These things are going to happen, and avatars are made, and again personality rights will come.
Correct.
And remixing is happening. And the cover version, again, we have given a statutory license for that. Yeah. Only limited use.
Yeah.
After 5 years only, that versions have to come. Tell me quickly, any other problem you have there?
I think we're almost out of time, but I feel like whatever we've discussed right now kind of clearly sets out all the possible revenue streams in the music industry. Like each of the points that Sir has talked about, these are all income generators for copyright holders. And I think the issues we are now soon going to start facing on a very rampant basis would probably be revenue generated by AI generated works. And who's going to be claiming
and there is a problem of market failure.
Yeah.
If already a song is existing, sung by Sonu Nigam, Shreya Ghoshal, the same is a remix version. Why is not allowed? Because original should not be a market failure for that.
Yeah.
If the AI, some voice comes like Sonu Nigam, Shreya Ghoshal, and they are singing all the songs, and there is a market failure. They lose their job, the work, and that has to be stopped. Recently, Delhi High Court judgment for the Jackie Shroff,
Arijit Singh,
Arijit Singh and that AI versions coming avatars behaving like that, personality, right? There's a good judgment initially to stop this. So I think law has to be modified, and soon there may be another version of amendments or a new law addressing all these issues.
Correct.
Otherwise, there will be a big problem.
Yeah. Because there was I think the ministry had basically come out with an announcement saying that the existing IP regime does deal with generative
the
AI.
parliament question came, so we replied.
Yeah, so I feel like to address any revenue
what we said,
blockchain
what we said that there are general provisions. If you see the section 2 subsection C, the artistic work definition, is the computer generated work. On computer you are generating, means AI generated work. Who is the author? Person behind that is the author. So even AI generated work, OpenAI doing, the ChatGPT writing something, or Midjourney creating some picture, or Stable Diffusion creating some music.
Correct.
But person behind that is the author, existing law. Now, next is the question of originality. So, there is a study of Petronius AI that all these AI versions, there is no originality, but existing data only it is picking up and creating.
So is it derivative works?
If you have written a song, you have drawn a picture that is in your drawing room, that has been not been digitized, uploaded. Can AI walk into your drawing room and your study table, read your song? Pick up that painting and drawing?
You can't,
So it's nothing but plagiarism, hi-fi plagiarism happening. So, okay, thank you.
Thank you, everyone.
We have taken extra time. Topic is so interesting. That's
So thank you so much, Doctor, for joining us for the second time round today.
Yeah.
We do have a lot of questions actually, especially to Sandhya. So I think a lot of students are waiting to ask you a lot of questions relating to music industry. So if you are willing to take a few of them.
Yeah.
Yeah, sure. I mean, but if you are running out of time, do you want us to?
No,
like
we do have time for Q&A.
for
So
Q&A?
Yeah.
Okay, great. All right.
Hi ma'am, my name is
Hi.
Aryan.
Hi.
Thank you so much for the session, it was really nice. So my question was regarding the last part of it, which is regarding AI and personality rights. How do you think the recent Mumbai High Court Arjit Singh's judgment, which is favoring Arjit Singh, actually takes a step forward in this whole scenario, which is actually quite dark?
Yeah.
And are we looking at amendments to the Copyright Act or a new AI policy in this regard upcoming to help artists out in this realm?
So there are two aspects here, right? Like the Digital India regulation, that is the touted Digital India Act, and also the new IP regime, which is all in works in progress. I would assume that this is going to be addressed because this is inevitable. Like now, generative AI is mainstream, but I feel like, I think more than anything else, there is also an expectation that there will be I think industry advancements which would address these issues before you have to take a regulatory stance. And also, given that India is an innovation hub, there is also hesitation in regulating, advancing technologies like AI and blockchain so much that it would curb innovation. So they have to take a very balanced call, which is why I feel like now today there are a lot of companies that are coming out with blockchain related solutions to problems arising out of generative AI. But honestly, if we apply the existing intellectual property laws, as is like Sir is also mentioning, there is still some gray area over there in terms of interpreting who the author is. Now, if the author is deemed the person sitting behind the computer and operating a platform like, I don't know, Suno, and creating music from existing works, right? Because Suno's trained on copyrighted material. Suno's already been sued by all the major labels. So does that output necessarily mean it's infringing? I mean, obviously, like I take the stance that it is. Because if you're training your platform on copyrighted material without taking necessary licenses and you are utilizing the platform for commercial purposes, basically you are licensing your platform out to an end user who's paying a certain subscription fee and generating music out of it. I might have absolutely no skill sitting behind the platform, but I am generating songs which are competing with artists of international standards and also generating royalties out of it. So there is a lot of monetization that happens at the platform level, at the end user level. So there has to be some kind of regulatory intervention there. So how and when, I think, is also like because if you notice, it's not, nobody has come barging in to regulate it. Where there are very few countries who have actually taken an active stance on it. Like Germany has, UK is still kind of contemplating it. US has probably done a lot more in terms of like announcing stuff. And I understand India's sentiment over here because you have so many like startup hubs. You look at Bangalore, Hyderabad, Pune, Gurgaon. And if you introduce any significant regulatory changes to these aspects, it impacts all of those startups and also in potential investment. So, I mean, I don't know if that answers your question, but I think it kind of leads to further questions. So, yeah. Yeah.
Yeah, ma'am. So that makes sense, but I just want to know where the money goes, like in terms of paying the person. So, like, let's assume, like, recently I was speaking to a friend, and there's a movie called Veteran which is coming out.
Yeah.
So in that, Amitabh Bachchan's voice is made using AI.
Yeah.
And it's dubbed in Tamil. So technically, the money for all of this is still going to Amitabh Bachchan.
Correct.
So why can't a similar approach be followed wherein
exactly.
the person's using AI to make...
You license their likeness.
Exactly.
So if you look at it, I think, what's her name? Elon Musk's ex-girlfriend. Yeah, Grimes. Thank you. Grimes did that. So she basically collaborated with a platform called ElfTech and licensed her likeness to the platform and said that anybody who's collaborating with the platform or creating further content using the platform will have to necessarily mandatorily split royalties and revenue with her, and she will be named as an artist. So see, that is a smart way of actually incorporating tech, right? Because, and this is something that I tell clients as well, that if you don't incorporate AI now, you'll find yourself getting left behind and you will be completely sidelined as a process. And also, like talking about Mr. Bachchan, he's licensed his footage speaking gibberish against a green screen for 2 years to a studio. And they've used that for Kalki, they've used that for like a bunch of other movies that are coming, because I mean, these are all practical constraints. Like you can't really show him climbing and jumping and doing crazy stunts at the age he is. And similarly, you have enough tech which is now converting a person's voice into multiple languages without it sounding unnatural. So these are great innovations for the entertainment industry, but it should not be misused. The problem is when we're looking at misuse. How do you address the misuse? But I'm aware that there is pressure on the industry to self-regulate. But whether we'll see any specific regulatory change addressing it is a different question. I would also think that things like if you're using AI-generated voices, which resemble a celebrity, for purposes that are fraudulent or pornographic, you should be treating it exactly like how you treat it with any other law, right? Why would you apply different standards? That is still a crime. Pornography and fraud is still a crime. So you treat whoever's created it should be dealt with accordingly under existing criminal law applications. So yeah.
Hi ma'am, I had 2 questions. Yeah. The first question is, ma'am, what is your opinion on the usage of the words royalty and fees in the Copyright Act? Are they used interchangeably, or is there a legislative wisdom or intent behind using them differently? And the second question is, ma'am, what is your thoughts on the current conflict between Section 30 and Section 33 of the Copyright Act? As you know, the collecting societies like PPL, NOVEX, IPRS currently aren't registered under 33, and the
IPRS is.
IPRS
has been re-registered.
I think 2022 it last expired. Yeah. I think they have applied for re-registration. Yeah. So I think there are conflicting judgments as well. The Madras High Court said you can't collect unless you are registered on 33, and Bombay, Delhi High Courts said the opposite. Yeah. And there is sort of a confusion there. So ma'am, what are your thoughts on that? And is there a way to sort of harmoniously interpret both these things together?
Actually, before I speak, I definitely want to know what Sir's opinion on this is. Because considering how actively involved he's been in the legislative side of this and the amendments, so could we deflect this question to him, and I'd like to hear his opinions, and then I'll comment.
Yeah, legally and technically, we didn't want any other aggregator to behave like a copyright society. Only a registered copyright society have to do collection in a particular area of subject. That's what is Section 33, one of the clauses we introduced in 2012 amendment. But we did not touch Section 30 because somebody said you take a famous singer is there, or a musician is there, he is not a member of these societies. And he is so old that he can't physically go and do collection. He will engage one agent to do this job. We leave that. Either voluntary license under Section 30, as well as the right owner, creator, or his agent. See, Novex is misusing this thing, that I'm an agent. This agency has become that they have 1,000 members. Now, yesterday only I heard that and new Novex ka baap paida hone wala hai. Somebody told me. Novex ka baap is coming. If a Novex has 1,000, we are going to have 10,000 members. And this is something going to create a big problem. And it is a kind of sub-licensing which we didn't want to encourage by the Copyright Society doing. But it is happening, and how is single window going to work? Will they come and join the single window users? Other day Hotel Association was saying that the price has to be set up after discussing with us. I said, when I go to your hotel for the dinner, and I always get shocked that dal tadka, 1,300 rupees. मेरे एक साल का दाल का price आयो 1,300 rupees. And are you asking me before you set the price on your menu? Why should music company should ask a hotel? This is ridiculous. And tell anything you are buying in the market. You are a user, consumer. So all the products sold or services are made available to you. Either the Vodafone or Zio or anyone, or a shirt maker or a shoe maker asking you, Bhaiya, kitna price karu?
Yeah.
Are you happy?
Yeah, nobody questions that. Correct. Yeah.
No person in the market will ask the consumer, wow, are you happy with the price? You want me to reduce? No. Like that, music also same happens.
Yeah.
Let them decide. You don't create.
Yeah.
But there is a Delhi High Court judgment. You have to take a license
mandatory
for commercial use of music. So it's like this.
I mean, I think, and I feel like the position of copyright societies, there's been like a overhaul in the image as well. And that's I think a large part of it is also because of digital distribution and how, you have author composers actually questioning where those royalties go and wanting to actually generate revenue from it. But the conflicting positions by Bombay and Madras, I think that becomes an issue which is then leveraged to the advantage of businesses, right? Like saying that no, if they have that understanding, they've used that against copyright society. So you'll see that even from a regional perspective. So an IPRS or a PPL or an RMPL, which is the current registered copyright society, functions very differently in different regions. But PPL is now technically acting like an authorized agent. They still just represent some of the large labels, and they just have collection agents who go from venue to venue threatening and creating a ruckus. It's not like how IPRS works. IPRS and Samra are more, I think,
passive,
yeah. I feel a lot more well behaved than this. So I just feel like this is not going to happen overnight, because it's also a cultural shift that is required, where the consumers of music also need to look at it as not a free product. Yeah. So business owners also need to have, there's a mind shift, there's you need to focus on. And hopefully the single window option is going to simplify that process. Because right now people look at it as a very complicated thing. So how many people do I need to pay? And
even All India Radio,
yeah.
I'm a regular resource person then. So I worked in All India Radio Doordarshan also. I take great pains explaining them, there is a performing right, there is a sound recording right, and the songs are played in All India Radio, FM, you have to take.
Yeah.
With Bharati Bhai, you have to take 3 licenses. They end up paying only 1.
Because they don't,
let sound recording company pay for it. Even the private FM broadcasters, they all say that our heart goes out for authors, composers, singers. Many are poor. And sound recording, we are paying to, they pay
and
only
they pay
one
them more
PPL
also,
or T series, and then they should pay it to them, not we.
Yeah, no, that will never happen.
They keep singing the same song, so now the same thing should come in single window. So where, as I said, whatever tariff is fixed, they will pay, everyone will share.
Correct.
Sound recording 100% go that share, and the performing share 50-50, performer share 50-50. And that was also not happening because The recent meeting with the initiative of Honorable Minister Piyush Goyal ji, the music companies and ISRA came together.
Correct, yeah.
And agreed and signed an agreement
where ISRA now gets a percentage of
50 crore mg they are to be collected and give it to you.
This, I think Sanjay Tandon
otherwise it's
also
not working.
this.
Not because of the Honorable Minister, two brilliant tools he introduced, the market to function monetization. This is one, bringing both together, and single window is his idea.
Oh, that's, as long as it's implemented, I think.
This idea. Okay, well, the last question.
Good afternoon, sir. Good afternoon, ma'am. So my question is, I have two questions. The first question is, are celebrity persona rights per se being protected in India? Because earlier it was the case of Delhi High Court where Amitabh Bachchan went for a COVID voice that he used to quote, "Mask pehenna zaruri hai," and that was being used by several telecom providers without, granting him due credits. And secondly, sir, as yesterday in the discussion we were talking about two songs. So now my question is, let's say I give a prompt to AI in such a manner to create a new song where the AI substantially is not taking a substantial part of one song but is compiling few parts of many different songs and creating a new one. So now, can that per se come under the copyright domain?
Yeah, it does.
The first thing, personality rights do exist, and courts have given decision not only in Amitabh Bachchan case, in Shah Rukh Khan case, in Anil Kapoor case, Jackie Shroff case recently, and they exist. Coming to the AI creations, already told, AI nothing original it is creating. It sounds like a original, but it's not original. It is only a compilation of existing thing. So I give you a best example. As a law student, you write an article and music rights. Okay, you are collecting information for this article from a number of journal articles, a number of books, a number of news published in online or physically. You collect everything, you paraphrase it. You paraphrase it. You said it's mine. I just read it. My expression, paraphrase, or written something. I'm not slavishly copying not even a word. I'm a master in English. I use synonyms for that. And created, my English is so good, I've written very good English, my own expression. I will not give a single citation or reference. Go to hell. It's my entire 5-page article is my original. Madam will put that in the turn it in. It says a 99% plagiarism. Please rewrite. Simple. Same thing applies. There are other artificial intelligence algorithms have come, just like Petronius AI, I'm ad nauseam telling. They're reading whether this is created by AI or not, ChatGPT or not, any other generative AI, and what percent is this original. So the so-called learning, so-called training happening by this deep learning or machine learning things is just like reading from the books and repeating that without citation.
Correct.
That's why US law is pending in the Senate has passed, pending in the court. There it says that law, if it comes through, any AI generated work, let us say that this is AI generated work, the AI has to specify from which source you have taken this phrase, this thing, everything citation, otherwise no copyright in that.
I think Professor
otherwise
Arul
it
had
will be
also
an infringement.
in the previous session.
Because AI, this service is not giving you freely. It's a subscription based model. Forget about ChatGPT 3.5. It is 100% AI hallucination is thus. I always ask questions on Indian law. It beautifully writes from EU law and them fools me. Because I know the subject, I don't get fooled. So, a couple of lawyers in American District Court got fooled. They filed an affidavit. It has created 6 case laws with citation. Judge is a learned person, caught that advocate, imposed a fine of $5,000, a simple token fine, because he admitted that, sir, it is written by OpenAI's ChatGPT. I failed to fact check it. So fact checking is very important. The AI works. It is not only plagiarism. It does AI hallucinations. जो पागल आदमी इमेजिन करते हैं ना, सामने कैटरीना कैफ बैठी है, अभी तो बैठी नहीं है, वो बिठा देता है. Thank you. Okay. Thanks. Jai Hind.
Thank you.
With that, we close the floor for questions. Thank you so much to the panelists for that very insightful session, and thank you to the audience for being extremely engaging as well. I now call upon our alumna, Advocate Muthamani Somasundaran, to present a memento to the panelists as a token of appreciation on our and our sponsors, Advocate Jijo Cherian and Ms. Apurva Reddy's behalf. I request the audience to stay back for the next session, which will begin shortly.
Hello.
Kochi weather and all compared to
I come here pretty often.
I think it's very humid.
Yeah, the heat, I think.
So you're practicing policy related mainly?
Yeah, I mainly advise tech companies. Regulatory policy stuff, but
government work also?
It's a mix. I mean, not as much government work as before because the government has also become suspicious now. But yeah, usually like we work with like companies. Sometimes the government comes to us with advice or like civil society. So tech is the area we mostly work in, but usually anything that nobody else in the firm does, which ends up coming to us. So
what do you say? It's an area that encompasses everything. So
more or less, basically whoever pays us, and it's tech companies right now.
Jack of all trades.
Kind of.
So how long have you been with Sam?
I joined during the pandemic, so like 20 months. You studied in Nuals?
Yeah, I graduated in 2023.
Oh, so
1.5 years.
My sister-in-law studied here. Aishwarya Manjuran.
Yeah, she was my senior. When I was in first year, she was third year.
Okay.
Participants, please be seated. We'll be commencing the session shortly.
Active alumni also. She comes from
she was studying.
She's not in the governing body this year, but last year she was there.
Okay. Nice, your alumni association seems very active.
It recently got active after it was a formal society. So we have to have meetings every year because of the rules, and that gives us an excuse to come and meet.
That's very nice. I was telling the students also, our alumni association is quite terrible. We don't really do anything.
And it's been a while since we actually have an international seminar. After the pandemic, especially, it's been hard to do those events. So we have to have the support of the alumni association as well too. So we'll start the session.
Yeah.
We'll be commencing the fourth session now. This session has been graciously sponsored by Ms. Lakshmi Menon and Ms. Haima Malini. And for this session, we have Advocate Puneet Nagaraj joining us. Advocate Puneet Nagaraj is a partner in the Public Policy and Regulatory Affairs team at Shardul Amarchand Mangaldas and Company. With a background spanning international organizations and major IT sector transactions, he has been at the forefront of shaping policy in data governance and emerging technologies. Notably, he was also invited to testify before the Joint Parliamentary Committee examining the Personal Data Protection Bill of 2019. Please join me as I welcome Advocate, who will share his insights on the cutting-edge issues shaping our digital future today. Please, sir.
Hi, good afternoon, and thank you for that very generous introduction. I was thinking through the sort of topics I could cover at this conference. It's a media and entertainment conference. I only incidentally do media and entertainment work. But I felt like content regulation is a very cross-cutting issue. And I'll go into a little bit of, what the journey has been under the IT Act at least, and, look at questions that we're currently facing. I also want to just get a sense of the audience. I want to warn you that there will be a lot of questions for the audience. I don't like speaking, just by myself for a long time. Are people generally familiar with the IT Act? Yes, no? Section 79 you're familiar with? Okay. So I also realized while preparing for this that it's been 15 years since the IT Act amendments of 2009. So it might be a good time to sort of stop and look at where we are. Just in terms of timelines, I'm mainly going to be looking at how sort of technology platforms are categorized from a content regulation perspective and what sort of issues that can give rise to. So just in terms of context setting, the IT Act was enacted in the year 2000. And a lot of people now say, and it's fairly accurate to say that it's kind of outdated, it doesn't account for how digital platforms have evolved over a period of time. But I'd say even when it was enacted, content regulation is not what it was designed to do. If you're familiar with the IT Act, if you look at the first few chapters, it deals with like electronic signatures, electronic records. Regulating content is not something it was envisioned to do, but because of the instance that transpired in the first decade, you'll see that it kind of became a regulation that ended up regulating content almost inadvertently. So as I was saying, in 2000 it was enacted mainly to sort of address the concerns of the IT sector, of the BPO sector, so that we could have a law that regulates technology in India. Is anyone familiar with the Avnish Bajaj case in the audience? The Bazi.com case? So that's kind of when the IT Act was dragged into there were instances before, but in the public domain for the first time that they had to address issues of content. For those not familiar, what had happened was there was an objectionable clip being sold on an e-commerce platform, and the CEO of the website was Mr. Avnish Bajaj was arrested. And that's kind of when they had to confront questions of intermediary liability. So the issue there was simply that there was third-party content that the platform itself didn't own, that didn't really have a role in it being uploaded. But because of the wide wording of Section 67 and the Indian Penal Code sections, you had the CEO of a company being arrested, which is when the parliament started looking at sort of amending the IT Act, and that's when you had the Safe Harbor amendments, which is what I'll be covering through most of my talk today. Now, the Safe Harbor amendments basically gave online platforms or intermediaries protections for third-party content. And then in 2011, you had the intermediaries guidelines, which also I will cover, which laid down the conditions based on which you'd get protections, Safe Harbor protections. And in 2015, again, you had the landmark Shreya Singhal case where Section 66A, which was very widely worded, was again struck down. And again, you have a lot of principles for intermediary liability that emerged from there. And finally, 2021 guidelines is what I'll be covering, where, in my opinion, it became more of a hodgepodge sort of regulation, where a lot of categories of digital entities which are not meant to be regulated under the intermediary guidelines were brought in within its ambit. Can anyone tell me what an intermediary is under the IT Act? I mean, you don't have to give me an exact answer, whatever you think. Yeah. sorry if we can have some mics.
Any platform that hosts third-party content on its platform.
Yes. Anything else? I think I saw a hand here as well.
So basically an intermediary in IT Act is one which is not posting the content after check and is not responsible in safe harbor for what it is posting, because it is the person who is posting. That is only providing the platform. So a platform provider could be an intermediary.
Okay. Anything else? Any other ideas of what an intermediary is?
Hello, sir. So it is basically a catalyst. So wherein, unlike Netflix, wherein third parties produce video telecasts, in this video telecasts as well as audio as well as written telecasts can be provided for, and intermediaries basically facilitate the provision of such information getting out to the public domain.
Okay. I think you're all getting at broadly the same point, which is their role is not so much hosting the content themselves, but facilitating the transmission of the content. And as I was saying, you had to come up with this category because in the Avnish Bajaj case, the owner of a website was, dragged to jail. So this is the legal definition of intermediary. I have a follow-up question for you. Because you're looking at the kind of, it is in, it's a prescriptive definition. So you have internet service providers, network service providers, web hosting service providers, search engines, online payments. Now, leaving aside what we just discussed on, platforms that don't put on their own consent, is there any online platform that wouldn't fall within this definition? Would it not fall under any of the categories? Yeah, so you're okay. That's good to know. And this is basically the theme of my discussion today is when you're trying to solve one problem, you end up creating a much larger problem. Is if you look at the definition of the intermediary, as I was saying, the intent was to sort of cover passive platforms that don't usually get involved in hosting content or, editorializing content. But if you look at the definition, and if you look at the internet as it exists today, or even, 10, 15 years ago, every single platform you could think of would fall into this category. And a lot of the issues we're facing today in terms of regulation basically arises from this. Now, the next step is safe harbor. One thing I want to clarify here is just because you're an intermediary doesn't mean you automatically get safe harbor. You can have intermediaries that don't get safe harbor. What happens to them is an interesting question that no case has sort of addressed, thoroughly enough. It's something that was out of the Avnish Bajaj case. So what you need to be for an intermediary to get, as an intermediary to get safe harbor protection is listed in section 79. One, as we were all discussing, is that your role is limited to providing access to a system. Your role is only to be the passive intermediary over, or dumb pipes, as people would say, over which information is transmitted. And second, you should also not initiate transmission, select the receiver of the transmission, select or modify the information in the transmission, and you need to observe due diligence requirements. Right? Is that clear? Any questions at this point? Anything? So one is, as we were just discussing, you have no role in the, you don't have no ownership over the content, or you're only providing access. But in addition to that, you should also not initiate, select the receiver or modify the content anyway. And you will see, as we will discuss examples, this is tested with every single platform. Every single platform. In addition, you had to observe due diligence obligations, which is what the intermediary guidelines in 2011 were, and was amended again in 21 and again 22, 23. And the one thing I want to do here is a lot of these safe harbor provisions come from the US. There's a long history of litigation in the US because of which they developed safe harbor provision. The equivalent provision in the US is section 230 of, I think, US Title 47. The important thing there is, right, when you're looking at a platform that does not own the content, that acts as a mere dumb pipe, as opposed to something that has control. So that's why I was asking, when somebody said Facebook, I said, what do you think of Netflix? The big difference with an OTT platform is that they are selecting content, right? They do have some amount of control over what they're putting up. Or if you looked at, historically speaking, like newspapers, or you look at any content that has an editor that goes through the content and puts it out, you can say they do have some amount of liability, or a TV channel, because they do screen content before they put it on. What is left unsaid in the IT Act is essentially that you're not a publisher. That distinction is much clearer in the sort of US provision where it says, no provider or user of an interactive computer service shall be treated as a publisher or speaker of any information. Right? So it's very clear that there's one category called intermediaries or whatever entities that get safe harbor protection, and there's another category of publishers. And this distinction is important to note because in the intermediary guidelines of 2021, all of this has been thrown up in the air and you get a big, as I was saying, hodgepodge of categories. So with the 2021 guidelines, within the broad category of intermediaries, there were four, I mean, you can argue that there's more categories, but there's four broad subcategories that were created. A social media intermediary, an online gaming intermediary, and as I was saying, the very notion of a publisher is opposite to an intermediary, but two categories of publishers are also included, though they have a separate regulatory framework, and there's an argument over when you stop being an intermediary and when you start being a publisher, but there's publishers of online curated content and publishers of news and current affairs content. Now what I want you to do is go through the definitions with me and have a few questions at the back that we can sort of go through and have a fun exercise. So we'll be going through the definitions of each of these and you can tell me which entities you think would fall within it and which entities wouldn't, right? So starting off with social media intermediary. Now you all remember the intermediary definition. This is on top of being an intermediary, this is what a social media intermediary does. Everyone can take a minute to read it. So it primarily or solely enables online interaction between two or more users and allows them to create, upload, share, disseminate, modify, or access information using its services. Again, can you guys give me examples of services that could fall under this definition? Facebook, okay, any? WhatsApp, Instagram, LinkedIn, anything else? Twitter. Those are all social media platforms, right? But is there anything that wouldn't traditionally be considered social media that could fall within this definition? What about email? Do you think an email service could fall within this category? No, it allows you should allow a user to modify. So user can modify, right? If I send you an attachment, you can modify it and send it back to me. When I send you an attachment? Good question. Does Zoom fall within this category? Think of the services you use every day, right? I mean, again, there's no right answer to this because if you go to the regulators, they will throw back the same sort of questions that I'm throwing at you. Can you think of other services that could fall within this definition? And this was a legitimate question that we got when the guidelines came out is email not a social media intermediary? So this is, again, the larger theme that I'm getting at is this, you create these categories, but in effect, it could end up affecting a wider range of services. And with each of these right now, basically, these are not just categories that exist in the air, there are obligations that come with it. There are things that if you don't do, there are penalties that come along with it. So with social media intermediaries, this is the problem. It's such a broad definition that even a one-to-one communication service, you could think of the traditional social media sort of companies and say it falls within definition. But the definition is so broad, things like email, Zoom was a good example. Think of most of your video chatting services could ostensibly fall within this definition. Sorry? Yeah. But is that a social media platform? Yeah. Or like MS, if you're using MS Word online and people can comment on it, are they not interacting with? But that's e-commerce, right? But what part of it? Yeah. Yeah. Or the other example I go for always is if you're playing on a gaming platform, right? You can talk to people also. Right? Yeah. So would that not fall? Again, these are interesting questions. We'll get to them in a bit. I have a couple of exercises to address these sort of questions. But I hope it's understood that the issue is it's so broadly worded, it can include anything. So now we'll go to online gaming intermediaries, which is a category created in the last couple of years. Again, if you go back to the notion, first of all, of an intermediary being someone who does not control the content, who has no role to play with the content. I'm sure most of you play games online. Is that true of a gaming company? Could you compare a gaming company to an Airtel or a Vodafone? Do they have more control over their environment? Do they have less? So let's go to definition. An online game is simply a game that is offered on the internet and is accessible by a user through a computer resource or an intermediary. An online gaming intermediary means an intermediary that enables the users of its computer resource to access one or more online games. So if you look at a traditional, I don't know if this reveals my age, but if you guys remember Farmville, which is something mostly played on like a social media intermediary, right? But would you then start saying Facebook is a gaming intermediary because it's allowing you to play this game? And you can still play games, right? I'm not on these social media platforms, but if you can play a game on it, if it's meant for something else. I think someone gave an example of an e-commerce platform. Or I don't know if you guys know when your internet goes off, Google search lets you play a game on their platform, right? Does that make it a gaming intermediary? Right? So again, this amendment again was introduced in a very specific context. The government was trying to clamp down on, real money games. There's a lot of provisions that govern real money games. But the question then becomes, does any game fall under this category? And is a gaming company, is it an intermediary at the end of the day? Because it's very different from how a social media platform would operate, right? It's very different from how a messaging service would operate. There's a lot of sort of content that they develop and they control. How much of a say does a user really have in it? Moving on. So these are the intermediary categories. Now publisher, as I said, globally it's recognized as a very different category of an intermediary. It's essentially the opposite of an intermediary, but it is still mentioned in part 3 of it's regulated in part 3 of the intermediary guidelines. This is a publisher of online curated content. And please take a couple of minutes to go through this and tell me what is not included here. So I'll just read through the highlighted part, and what I want to stress on really is publisher of online curated content. Is a publisher who performs a significant role in determining the online curated content being made available, enables such users to access online curated content over the internet or computer networks. Can you give me examples of something that could fall within this category? Yeah, that's a good point, but there are things that distinguish it. So the difference between online curated content, right, is if we look at Q, it says any curated catalog of audiovisual content other than news and current affairs. So it has to be curated, as opposed to a social media platform where it's just user-generated content. Here the platform themselves is curating the content, right? So the intent, I would say, is to regulate something like a Netflix or a Hotstar, where there's some amount of curation going on. Something that's being made available on demand. But I agree, there is some, what for instance is not explained here is what does curation mean? Who is curating it? So if you have an algorithm that's sort of sorting through content, decides what you see on your feed, because that's not fully in your control, right? Does that make it curation? What is the threshold? I'll ask you a more ambiguous question. Where does YouTube fall in this? And is YouTube the same as Netflix? So which category do you put them in? Is it a plain vanilla intermediary? Is it a social media intermediary? Is it a publisher? But he's saying they have their own content as well, right? And there's a paid tier without ads and but social media platforms also have that, right? Again, there are no right answers to this. But this is the point that as a publisher, it's the exact opposite of an intermediary. You have no role. Finally, publisher of news and current affairs content, which is functionally the same as a OCCP, which is the previous category, but it focuses more on news, which is online paper, news portal, news aggregator, news agency, and other such entity, which is functionally similar to publishers of news and current affairs content. Again, any examples that could fall within this? Sorry? Okay. I'm not familiar with that, but I'm assuming there's a lot of current affairs topics that's posted there. Okay. Anything else? Have you guys heard of like InShots? Would that fall here? Google News? What about social media platforms? A lot of people get news on like Facebook and Twitter, right? Would that fall within this category? Why not? Why? I mean, again, no right answers or wrong answers. Any thoughts? Would a social media platform fall within this definition if they're publishing news? How? Okay, let's jump to the answer. There again, it says it's functionally similar to a publisher of OCCP, right? You have to go into curation. Are they actually curating that news? So it's why someone like a news aggregator who's actually sifting through the content, like with InShots, I think they write their own summaries, for instance. There you can say they are a publisher, they're coming up with this content themselves. But again, what I want to emphasize here is the lines are so blurred. 3 people read it, they can have 3 completely different interpretations of it. With that in mind, I have 2 questions. Please read through them and just tell me what you think. It's again in the same line of the discussions we were just having. So this is the first one. Okay, can it be anything else? And then can it be anything else? What about the monetization and the streaming? Like Twitch, you guys are familiar with Twitch, right? So where would you classify a service like that? Could that be a publisher? Okay, but what about monetization? Could you say that they're incentivizing? Yeah. So the same question I was asking with YouTube, right? There are featured people, there are places. Again, I'm not saying that it definitely falls within this category, but the definitions are so broad. I think we've gone through all 4 categories now, right? Any other thoughts on this? I think we've discussed that it can be a social media intermediary, it can be a gaming intermediary, it can even be a publisher. Sorry? Yeah. So that's my second question. Anything else? What kind of publisher? What kind of content are they carrying? So it'll be a news publisher. But how is it a publisher? Are they doing any curation? But is merely promoting content enough to say it's a publisher? Because they're not producing the content themselves, right? I mean, it's what we were I'm just asking the same question in another way. What we were discussing in having featured content or saying this is, does that make it? Yeah. Yeah, I'm asking the same thing the other way. Is it sufficient to be curation? Because as I was saying, if you go back to the original discussion we were having, right? Is it their content? No, it's somebody else is putting it up. They're curating it. Does curating make you stop being an intermediary? You start becoming a publisher when you start curating it? What if they're not making any modifications and they're just posting it as is? Or like you could be a social media user, right? And you're just retweeting somebody else's content. Someone can say you're curating it, but you're not publishing it, right? Sorry? But that's not what, impact is not what's being regulated, right? It's your actions and... Yeah. So again, all of these platforms do have a huge impact, and that's why they're trying to regulate them. But in terms of like their activities they're engaged in. And again, a lot of these are real life examples. A lot of these are actual questions that come up day to day when you're dealing with this. I just thought I'd give you a flavor of what happens. That brings me to the end, but these are the sort of 2-3 things I want you guys to think about. One is digital platforms blur the lines between broadcast, streaming, and sharing content. I mean, this is not, because what we're discussing is legal categories, right? This is fiction. Day to day, people do like 5 different things on one app, right? And we don't even have like super apps like they have in China, where you can do cab delivery, you can do food delivery and watch stuff on one app. But we're kind of getting there with some sort of platforms at least. As we discussed this, you can chat on a gaming platform, you can, watch news on a social media platform. So the lines have always been blurred. We are trying to create legal categories. So one of the solutions that like one sort of high court has offered is maybe you can split the platform up and say this is the intermediary part, this is the social media intermediary part, but that is insanity of a different kind. But the thing to keep in mind is that the way these platforms exist, there isn't one kind of category that applies. A lot of times, a lot of this classification happens post the fact in practice. The other thing that's happening, right, and that's the very first point I made, that under the IT Act, content regulation was inadvertent. It's not what it's meant for. So even now, if you go to the Ministry of Electronics, the first thing they'll tell you is we don't regulate content. And the Ministry of Information Broadcasting is trying to come with a broadcast bill that regulates OTT. But what is authorities have come up with? SEBI is coming up with some influencer guidelines. Again, they're not content regulation per se, but they inadvertently start regulating content, just like the IT Act did. And finally, IT Act reform is something people have discussed for 2-3 decades, I mean, since its inception almost. Again, there's a lot of interesting ideas there. One proposal last year, for instance, was to do with the category of intermediaries altogether. What that means, implications of that is something, for people to study and think about. But that was the end of my presentation. Thank you very much. I hope you enjoyed it.
Thank you very much, sir. Owing to the paucity of time, we won't be entertaining any questions for this session. But thank you for that truly, truly interactive and insightful session, sir, once again. And I would now like to invite Advocate Rahul to present a... Thank you, everyone. We're ready to break for lunch now. You can, the lunch will be